So good morning, everyone who is joining us for this webinar on the execution of the judgments of the European Court of Human Rights. My name is Başak Çalı, and I'm a professor of international law and co-director of the Center for Fundamental Rights at the Hertie School. And it is my pleasure to welcome you all to this workshop on behalf of the Center for Fundamental Rights and my team. And we're very, very happy to have collaborated in the organization of this workshop with Middlesex University in the UK and Professor Philip Leach, as well as Germany's Ministry of Justice and Consumer Protection, and on the occasion of their chairship of the Council of Europe at this time. So you know that compared to the scholarship on the case law of the European Court of Human Rights, its jurisprudence, research on the execution of the judgments of the European Court of Human Rights is a much younger, but also a very rapidly developing field. This is also a field of academic research that really lies at the intersection of law and political science. And today we have an amazing wealth of scholarship and experience with us today throughout this workshop. And I'm very much looking forward to listening to both the leading scholars of this field from law and political science disciplines, as well as leading practitioners on the execution of human rights judgments. And I have no doubt that once we finish this workshop, that our collective understanding of human rights judgment implementation in Europe, the challenges and perhaps some new ideas will be much advanced. So let me give the floor to my co-organizer, Professor Philip Leach, also to say a few words of welcome.
Many thanks indeed, Başak. It's a great pleasure for Middlesex University to be collaborating with you and the Center for Fundamental Rights at the Hertie School. I'd also like to commend the German government for prioritizing this absolutely critical issue of the implementation of European Court judgments during its presidency of the Committee of Ministers of the Council of Europe. I'm really looking forward to our discussions today and hope that this workshop will help lead to real improvements in the rates and degrees of implementation by member states. Thank you very much.
So let me also give the floor to Dr. Jacobi to say a few words of welcome on behalf of the German Ministries of Justice and Consumer Protection.
Thank you very much, Professor Çalı, and thank you very much, Professor Leach, for these warm, welcoming words. On behalf of the German presidency of the Council of Europe, which is slowly nearing its end, and the German Federal Ministry of Justice and Consumer Protection, I would like to welcome all of you today for this really important workshop. And I would like to express my heartfelt gratitude to the Hertie School and Middlesex University for this excellent organization and a very interesting program that awaits us. There has been great interest in this event, reflected by the large number of registrations. To me, this seems to be a very clear confirmation of our choice to focus during our presidency on the special role of the European Court of Human Rights and to explore ways how to further improve the court's unique human rights protection mechanisms. In particular, the implementation of its judgments, which is so crucial. The execution of the court's judgments by the member states is a key element towards achieving a sustainable and very robust and effective implementation of the rights laid down in the European Convention of Human Rights. I'm therefore thrilled that so many highly qualified persons reflecting a wide range of professional and geographical backgrounds have agreed to join us today. Academics, government officials, members of national human rights organizations, Council of Europe staff, as well as members of the civil society, all of them originating from many different member states and each of them playing their own very own role in the safeguarding of the rights laid down in the European Convention of Human Rights. I'm confident that the diversity of our participants will greatly enhance the discussion and contribute to obtain findings representing a very broad range and full picture of the situation viewed from a number of angles, and very different angles, in fact. With this in mind, I wish all of you, all of us, a very fruitful discussion. And it is with great anticipation and honor that I now hand over the floor to the Secretary General of the Council of Europe for her opening remarks. Thank you very much.
The execution of judgments of the European Court is of the highest importance to both the European Court of Human Rights and the Council of Europe as a whole. Ensuring and improving it is the stated intention of our member states and a key aspect of my four-year strategic framework. This is because the credibility of the Court and the entire convention system depend upon human rights laws being enforced in line with the legal obligations freely undertaken by all our member states when they ratified the European Convention on Human Rights and joined our organization. The full and swift execution of judgments is the responsibility of national authorities. But it is the Committee of Ministers that supervises the process. So I thank the German presidency for making this question one of its priorities, and I am grateful for its co-organization of this event with the Hertie School of Governance. The European Convention of Human Rights has had an outstanding impact on our countries, societies, and everyday life over the past 70 years. To a large extent, this is due to the significant efforts made by our member states to comply with their unconditional obligation to execute the judgments of the Court that find violations against them. Nevertheless, execution of the Court's judgment is not always easy. Those that highlight the existence of complex structural problems requiring coordinated action by different branches of power, and those that concern conflicts or affect deeply rooted traditions. These are examples of where execution may be particularly difficult. Through its work and expertise, the Council of Europe is able to provide assistance in such cases, often based on solutions identified in other countries' experience of implementing the Court's judgments. So I encourage our member states to draw on that expertise wherever useful. Today's workshop is an ideal opportunity to explore how different convention actors, both at national level and here in Strasbourg, can best respond to instances of delayed or deficient execution and even resistance to act. So, I hope that your discussions are stimulating and productive, and I will certainly take a keen interest in the outcome of your work.
Thank you very much to everyone, in particular the Secretary General of the Council of Europe, for these warm words of welcome and opening statements. So before we move on to the substance and to our discussions, let me just give you a few of the housekeeping information about our brand new lives, or not so brand new lives on Zooms and webinars and all these technicalities. So the first thing is, as you would have seen just from the top left corner, is that this event is being recorded. And this is an information that you would have received when you also log in. One of the ideas of the recording is perhaps to make some of the presentations that are made throughout the workshop also available for later on for others to also benefit from them. We have 3 papers, 3 presentations in our substantive panels. We have 3 substantive panels on delayed execution, deficient execution, and also resistance to execution. And after these papers and presentations, we will have about 45 minutes or so for discussion and for a Q&A session. And we really welcome all the participants to take part in this. And let me just explain, I'm sure you may have heard this many other times, but how to participate in the latter session of this. So there are two ways. You can either make comments or questions by writing them. And we would ask you to use what is called the Q&A function of Zoom. And this function is just at the bottom at the far right corner of your screens. And when you click on it, you would be able to pose a question, and our chairs will be monitoring that in order to follow your questions and comments. We ask you not to write questions on what is called the chat function of the Zoom, which is on the right, is it? Yes, it's on the right-hand side of your screen. And I think this just really helps chairs to focus on the Q&A function to follow questions and answers. So please do not use the chat function for that. Now, but we also really warmly invite those attending amongst us to ask questions in person. I just know from the registration list for this workshop that we have an incredible wealth of experience amongst us as participants as well. So if you would like to make a comment or ask a question, then please just use this function called raise hand, which is also at the bottom of your screen. And then once you raise your hand, we will then turn on your microphone and your camera, and so you will be able to ask your question in person. So both of these options are possible for participation, and please do choose whichever is easiest for you. One of the things that we would like is that we would not like to accept anonymous questions or comments. So please, when you type in your questions and comments, indicate who you are, your affiliation and so on, and that will be very helpful for us to follow. So these are some of the technical bits of information from me. If you do have technical problems throughout this webinar or accessing some of the issues, you can contact us via the chat function if there's some sort of a technical issue that we could then perhaps monitor or try to help you throughout. So without further ado, let's start our substantive panels and discussions, and I'm really looking forward to every single one of them. So let me give the floor to the first chair of this workshop, to Claire Ovi. She is the head of the execution department at the Council of Europe, and I'm delighted that she has accepted the invitation to chair also this first session. Over to you, Claire.
Thank you very much, Bashak. So good morning, everyone. I'm also extremely delighted to have been invited to chair this first session of what promises to be a very interesting event today. So our topic this morning, the first topic is delayed execution. In the Department for the Execution of the Judgments of the Court, we keep statistics recording the number of cases still awaiting full execution. 5 years after the European Court's judgment and 10 years after the European Court's judgment. So these are the cases that we count as a kind of backlog cases. So cases where there's delayed execution. It doesn't mean, obviously, with these cases that nothing has been done, but it means that full execution has not been achieved yet. And these statistics are published in the Committee of Ministers' annual report, which is also available on the Department for Execution's website. So just to, I don't want to kind of bore you with too many statistics, but this month we have a total of just over 2,000 cases which have been pending for more than 5 years. This is down from a massive high of about 6,500 cases of over 5 years in 2015. And today we have just over 900 cases which have been pending for more than 10 years, which is down again significantly from a high of about 2,800 in 2016. These decreases can be explained by the change in the Committee of Ministers' practice which took place in around 2015-2016, where the Committee of Ministers decided that it would close repetitive cases where no further individual measures were possible, but keep leading cases. So that we classify leading cases as cases which raise a new human rights issue for the country concerned, which generally requires general measures to correct it. So if we look at the statistics for general measures in terms of delayed execution, in terms of leading cases in terms of delayed execution, we can see a steady increase in the older cases, particularly those pending for more than 10 years. We're still not talking about huge numbers of cases, but in 2017, there were 200 leading cases pending for more than 10 years, and we have today 300. And the number of cases pending for 5 years or more remains stuck at around 650. This is also partly, it must be said that the Department of Execution, working with the states concerned, has made a huge effort to close some of the easier cases to close, and we're now left with a core of really old, difficult cases, which will take more concerted efforts from the states concerned to close them. My distinguished panel this morning will help us get to the root of this problem of delayed execution, and also suggest some tactics which we could use to combat it. Each panelist has around 50 minutes to present their papers, and then we'll have around 45 minutes for discussion and questions. And as Bashak explained, you can use the Q&A function on the Zoom screen. So our first panelist this morning is Øyvind Stjansen. He's a political scientist working at pluricourts at the University of Oslo, and he's currently conducting empirical research on compliance with judicial decisions, amongst other topics. So, Øyvind, you have the floor. Thank you.
Thank you very much. Can you see my screen? If so, please nod. Yeah.
Yeah, that's fine.
So I'm Øyvind Stjansen. I'm a postdoc at University of Oslo, the Pluricourt Center for Studying International Courts. And what I want to do today is to explain a little bit about the database we have been working on for European Court of Human Rights judgments in general and their execution of those judgments by respondent states. I'm not really going to advocate for any single paper or finding. Instead, I'm going to give you an overview of what this data suggests about the most important causes for variation in what delays or speeds up the execution of judgments. So first, this might not be the mode of research that most of the participants are familiar with, so I thought I would just briefly introduce the database and what it might be useful for. So first, what is this database? It's joint work with Erik Wootton at Georgetown University, so hence the name. It contains all European Court of Human Rights judgments, published decisions, separate opinions, and execution processes. We gathered this from the various Council of Europe websites, UDOC exec, that's obviously very useful, but it's not really in the format that you would need to do statistical analysis and the type of things that we want to do. So what we have done is to download all that information and to systemize it in a format that's more useful for systematic analysis. For the most of the website, it's current through 2019, but because some of these execution processes, it takes a very long time to gather all the information submitted by states. Communication with the Department of Execution, that's only current until June 2016 at the moment. And if anyone is interested, we made all of this publicly available at this website. So for the purposes of this workshop, what's most interesting, obviously, is the execution processes. So what we have done is to gather all the leading cases, which Claire explained what are so the first cases to identify a new problem in a specific respondent state. And then we track how many days it takes from that lead judgment is rendered until the execution process is closed by the Committee of Ministers through a final resolution. So that's sort of the outcomes that we're interested in explaining, both whether an execution process is eventually closed, and if so, how long it took. We also include hand-coded measures of the type of measures that respondent states are asked to implement, both the general and the individual level measures. So this is one of the things that really takes a lot of time to code based on the information. I'll get a little bit back to why that is important in a moment. So what, if anything, might this sort of approach be useful for? Well, I think there are two main purposes of a reason why we need to take the time to do it in this way. So the first, which we also heard some examples of in the introductions, is to try to describe the general patterns. I think this is how most people consume this type of statistics, is to understand like how long does it take in general, how many cases are still pending, and so on. But there's also another use, and that is to try to test a different hypothesis concerning specific variables that might influence the execution process, in this case, speed up or delay execution. So very often researchers will focus on individual cases, sometimes the very problematic ones, because those are interesting. Sometimes people ask, but what about the success stories? I think that's, of course, very useful in getting good ideas about what might delay or speed up execution. But in order to understand if those factors are really systematically important, you need variation both in those factors and in the outcomes you're seeking to explain. And for that purposes, I will argue that a database is very useful. So what might it be less useful for them? Well, we're operating at a level of abstraction here, so it's not that useful to understand specific execution processes maybe. And also there is some delay because we're studying history here. So European Implementation Network, I think, started up most of its activities from 2016. So I think that's probably very important, but it falls after our database. And same for some of the reforms that Claire talked about in the introduction. Okay, so I'm asked to talk about delayed execution. I find that term a bit difficult. And here is the reason. So this is a description of how long it usually takes. So this is something called a survival curve. So on the horizontal axis, you have the years it takes since the lead judgment, and on the y-axis, you have whether the judgment or the share of judgments that are still pending execution. And this, when this starts, it's at 1 because all judgments are still pending, and as time goes on, more of them are implemented. So the good news here is that most judgments are executed eventually. I think it's important also to note that this curve continues to drop. So even judgments that are have been pending for very long don't seem to really lose their momentum. So even in those cases, there is a high chance that the judgment will eventually be implemented. But then there is, of course, considerable variation in how long it takes. I think the median here is a bit more than 4 years, which of course means that many of these lead cases take more than 4 years to complete. And it's useful, rather than to talk about delayed implementation as an outcome, it's useful, I think, to consider the factors that delay execution relatively to other execution processes. So that's what I will focus on with the remainder of my time. So the first thing is that the individual level, the individual execution process, we coded the types of measures that were needed. So we classified these as legislative, jurisprudential, practical, executive, administrative, dissemination measures, and then individual measures. The main difference between the practical and the more executive administrative measures here is whether there's just a rule change or change in what bureaucrats are told to do, or if some changes need to happen on the ground, such as rehabilitating a prison, that type of thing. So there is variation both in which one of these are required and how many. So if many types of measures are required, that may indicate, or that might be one way to identify more structural problem where more branches of government will need to collaborate and so on. And these different curves are then for different counts of how many of these are needed. The areas around the curves are confidence intervals, so they indicate the uncertainty. So we're very uncertain about the exact effect of having 6 different types of measures needed, because there are not many of those cases. But what is very clear is that each additional measure needed tend to delay the execution process quite significantly. And one way to interpret that is just that the some of these need to happen in sequence. So individual measures might happen after jurisprudential or legislative measures, and also more actors need to collaborate, which tend to delay the execution processes. We have also looked at individual types of measures and if they tend to delay execution. Here, legislative changes and practical measures stand out as particularly important, but there are a bit differences between those two. So the need for legislative changes delay execution initially, but does not reduce the long-term likelihood of execution. So knowing that something will require a legislative change tells you that it's unlikely to be implemented in a matter of months, but it doesn't tell you much about the likelihood of long-term non-compliance. This is a bit different for the practical measures. So these seem to also correlate with very long-term non-compliance, which I think it's at least important to note in understanding these processes. So the country level variation is obviously also important. Just to illustrate, I put the general curve and then 2 countries, United Kingdom and Czechia, as examples of countries that tend to spend less time than the average in the Council of Europe. United Kingdom has received a lot of attention for some judgments that have been pending for a long time, but on average does quite well. Czech Republic is an example that this is not just the old member states, it's also some of the newer member states do quite well in executing judgments in a timely manner. What might explain these country level differences? 2 big factors here. The first is the bureaucratic capacity of the respondent states. So these are predicted number of years between a lead judgment and final resolution for the highest observed level of bureaucratic capacity and the lowest observed level in a statistical model that controls for the specifics of the case and also other country level factors. So the difference here is between 4 years and 10 months for the lowest capacity and 3 years and 5 months for the highest capacity. And those numbers are obviously driven also by assumptions about other variables in the model and so on, but that gives you sort of a ballpark estimate of how this country level factor influences the time it takes to implement these judgments. The other type of factors that seem very important is the domestic institutions that keep governments accountable. So these are both legislative constraints on the executive and so on, but also more informal ones like civil society, a free media. And yeah, this is a similar type of graph that shows the differences in the predicted number of years for the strongest government accountability and the weakest ones. And it's 1 year and 8 months difference. So again, that's sort of a ballpark estimate on how much this type variable matters on average, controlling for other things that are also important. So I realize I don't have a lot more time left, but we also have one project that looks at Article 46 judgments, which are judgments of the court that indicate remedies that might be required. The trade-off here is that this increases transparency, which might make it easier to hold states accountable, but it comes at the cost of reducing flexibility, both for the states and also for the Committee of Ministers in their interaction with the state. Point to note is that the court has been very selective in indicating remedies. So these are differences between judgments in which Article 46 indications are given and other types of judgments. So they tend to be given against states that lack bureaucratic capacity, that has lower levels of government accountability, but also cases where more is needed in terms of the measures, legislative changes, practical measures, and so on. Also, more articles of the convention tends to be violated in these cases. So these comparisons are based on selecting cases that are comparable, not comparing the Article 46 judgments against the universe of other cases. When we do that, we find that Article 46 judgments are associated with somewhat shorter times under supervision, so quicker execution of judgments. This is a finding that obviously only then holds for these type of cases in which Article 46 judgments tend to be rendered, which are different from the broader universe of cases. That's important to keep in mind. Also important to note that the effect seems to be highest where there is some level of government accountability. So it might not be a useful strategy where government accountability is very weak. I'm over time, but just my last slide, the conclusions. So as we all know, most judgments are executed, but considerable variation in how long it takes. The number and type of remedies is important. Individual level factor in explaining the length of execution process. Capacity and accountability are important country level factors. The Article 46 indication seems to have worked in the type of cases where they have been offered, but then again, only where domestic institutions enable accountability politics. So far, there is little research, unfortunately, on other types of strategies that might be helpful in improving compliance. So I hope that's where the research will go in the future. Thank you for the attention.
Thank you so much, Oyvind. That's extremely interesting, and I think a very good start to our discussion this morning. Really just pulling out the factors which can lead to delayed execution, factors coming from the complexity of the execution measures required, but also very importantly, factors relating to the country, the capacity within the country, and democratic accountability within the country, which are perhaps things that we could discuss a little later in our panel. So my second panelist this morning is George Stafford. George is the director of the European Implementation Network based in Strasbourg, which serves as a hub for civil society organisations within Council of Europe member states, advocating for the full and timely implementation of the European Court's judgments. George, you have the floor. Thank you.
Thank you so much to Claire, and thank you so much also to all of the organisers of this event. It's a real pleasure to be here. I was fascinated by the previous presentation, and I'm looking forward to hearing more from everyone else. So I think what I'd like to do today is just present a little bit of an overview of a couple of different ideas, at least from the point of view of civil society, about how to address delayed implementation. I'd like to start off, hopefully you can share this, you can see the screen, with just where we're starting off from, which is a really welcome existing consensus, let's say, on behalf of those who are interested in protecting the convention system on the real depth of the problem of implementation. There's some examples listed there, I think really interesting, all three of them. I'm really interested to see that it's a priority of the German presidency. It's been highlighted in recent reporting by the Council of Europe really, really strongly. And of course, I think it's also the #1 strategic prioritization of the Council of Europe Secretary General for the next 4 years, which is a very welcome development. The question is, how do we address it? Now, this presentation isn't comprehensive by any stretch of the imagination. It's just to promote a couple of different ideas. It also doesn't really come from the point of view of what the Council of Europe or the Department of Execution can do. We're perhaps not best positioned to address that. But it does present some tentative ideas resulting from the recent experience of civil society. And I think that the starting point from my perspective would be that non-implementation is just a huge long-term systemic problem. It can only really be addressed through large, long-term systemic solutions. In particular, I'd like to mention 2 different ways of approaching it. One being solutions from the sort of bottom up, and that's from within countries themselves, civil society, parliamentarians, media, activists, and also solutions perhaps more from top down. So that's from international institutions or other states which have real influence over the conduct of particular governments. So we're going to start with bottom-up solutions, and it's a kind of truism, I think, to say that this change, implementation has to come from within a state. And I'd like to put forward the case that civil society is carrying out a huge role in this area and can also do more. And that's in particular through a series of different things. I think the previous presentation was really interesting, I think, in highlighting the importance of bureaucratic capacity, but also accountability of state actors. And I think we're going to touch on that in the coming slides by saying that civil society can have a huge role in advocating for the creation of implementation structures within states, monitoring those structures to make sure that they operate on an ongoing basis, holding the government to account both privately and publicly for non-implementation, and also carrying out public advocacy on particular cases. So just a really quick word on implementation structures. I think it's generally known how important these are. There's some examples there of the different ones, and it's already been raised in the last presentation. But I think overall, it's just really important to note that these provide systemic structural oversight to address the systemic challenge of implementation. And that can be done, of course, through parliamentary oversight mechanisms, so normally subcommittees within Parliament, and also executive working groups and made out of ministers or representatives from different key government institutions. And there's some statistics there to reflect the fact that where these operate well, they lead to low levels of pending leading judgments. Leading judgments, of course, being those judgments that identify systemic or significant problems and require reforms in general measures to solve. And that's really the most important part of execution that will prevent further cases coming from the court. Okay, so just a really quick example of one that's recently come to light or is in the process of being made. It's in Moldova. Moldova has a really serious non-implementation problem, has a high level of pending leading judgments. Interestingly, I think it's worth noting that really for Moldova, the cases under enhanced procedure, there seems to be a lot of really effective and interesting activity. But for those large numbers of cases under standard procedure, there's very little activity indeed. So it's a place in need of structural reform. It's important to say, I think that's in the process of being made. The rules of procedure of Parliament were amended in November 2020, this will lead to the creation of a subcommission that's dedicated to monitoring the implementation of ECHR judgments when the political process resumes in Moldova. And the question is, how did this come about? The answer is very much civil society. So the Legal Resources Centre Moldova have been campaigning since 2014. And they're really the kind of tip of the spear in pushing forward the reform there. They initiated the proposal in Moldova. They drafted the amendment to the parliamentary procedure. They conducted a huge amount of advocacy and also a large array of media appearances. Other organizations there worth mentioning, of course, Premo-Lex, another significant Moldovan organization. But I think from the point of view of at least of LRCM, is that this would not have happened without them. In addition to the creation of these structures, it's also important to note that it's important to monitor them and make sure that they work over time. A lot of them, unfortunately, are kind of empty shells that don't operate in a really effective way. And that's another way in which civil society can make a big impact. There's also the issue of public and private accountability for non-implementation. Just a quick example of how this can operate. So just before the start of the pandemic, the Human Rights Committee, Helsinki Committee Vanadzor in Armenia, along with European Implementation Network, held a public debate in Yerevan, as well as a series of private meetings with government actors. And one of the key things which was raised was just that of all the leading cases in Armenia, half had no action plan or action report to the committee ministers. So that's to say, there's no sort of activity going on from the government side to say, here's what we're going to do to implement this case. So this was raised quite prominently near the start of the year. And during 2020, there was a huge increase in the reporting. So you'll see there's a kind of increase by a factor of 5 in the number of government action plans, action reports. And now actually every single case in Armenia that became final before 2020 has an action plan, action report. Now it's important to say a few caveats. One is that there may be other things going on, activities by the Council of Europe, etc., that helps also promote this change. It's also the case that just the submission of these plans and action reports does not indicate activities, although it hopefully indicates intention. And also Armenia was a particularly good place, or good opportunity to do this. Nevertheless, it seems to us that this is a really good example of how civil society can provide that public accountability that was mentioned by Mr. Stiansen, and how important that can be in pushing forward implementation. I don't have too much time just to discuss implementation of individual cases or raising that, but just a really quick example, 4 free speech judgments against Moldova pending for over 10 years, almost no government reporting in that entire time. NGOs there published a statement leading to a TV news report, and in the report it details how a government agent sort of responded in writing to say, okay, yes, we'll bring forward reform proposals during 2021. There's many other different examples, I should say, of activity at the national level by NGOs dedicated to a particular issue, promoting implementation activities. So in summary, I think, I've mentioned implementation structures, creating and monitoring them, making sure they work, public and private accountability for implementation overall, but also individual cases. Why is it effective? Why is civil society so important here? They're from within the state. It's so often said in the human rights sphere that states, governments and populations are tired of change trying to be imposed from the outside. It's really important civil society is leading this charge from within. They know the terrain there politically, and they can know when to push for things and when to get things done. They can build alliances in the legislature, in government, and the judiciary, in the media, and they can carry out this advocacy for a long period of time. So it's also important to say, however, that actually there's a lot of states where this isn't happening. I've selected some really interesting examples, but I would say for the majority of states that need this kind of systematic accountability from civil society, this work isn't really happening. Why? Well, we did a survey of NGOs last year that asked this exact question. What are the main barriers that prevent more advocacy on promoting implementation? And this wasn't just of any old NGOs, these were the NGOs that have most involvement in the implementation process in Europe. And the majority of the 27 different responding organizations said that the #1 reason that they didn't get more involved was financial capacity. It's difficult to give an overview of all the different types of funding for NGOs throughout Europe, but they happen at the national level, from institutions, from private philanthropies. But I think it's fair to say that overall there's a shortage of large grant-making facilities for civil society to carry out this kind of work at the national level from the ground up. So our recommendation is that philanthropies, institutions, governments can fund civil society activity at the national level to do the kind of activities that we've mentioned. And that would be a really, really important thing to systematically improve implementation over the long term. So that's the sort of bottom-up arguments I've been making. Now let's turn to top-down. And that's, again, as I said, from international institutions or states that can have a level of advocacy or pressure. Even punitive measures are sometimes discussed. It's important that these proposals are realistic. We're conscious of the fact that some ideas, of course, would be most effective, but perhaps can't be implemented. And also, I think the first point of departure for most people will be the Council of Europe. That will be discussed a lot more later, I'm hoping, particularly in a session, the third session today. So I actually don't want to use my time today to talk about the Council of Europe, but to say perhaps that there's other places that we can look to. And I'm going to concentrate now on the European Union. So the EU is the continent's economic powerhouse. And not only does it have money to distribute to its member states, but countries within and outside need to have a strong relationship with the EU to maintain trade connections. The costs of opposing the Council of Europe can sometimes be fairly minimal. The costs of opposing the EU could potentially be quite substantial. And the point here is not that the EU should take over responsibility for European Court of Human Rights implementation, but that it can use European Court of Human Rights implementation in its own processes because it's in the EU's own best interests. And I'm going to talk now a little bit about internal and external EU processes, with a focus on internal. Now, the rule of law review has really stepped up a lot in the last few years. There's some existing measures there that pre-existed the developments from 2020, but last year there was the development of the rule of law review cycle. Now that's an annual mechanism where there's a review by the EU Commission of the status of rule of law in every EU member state. And in December last year, there was also the creation of the budget conditionality mechanism. Now, the exact operations of that are yet to be determined, but it's important to say that it's likely to take into account the findings of the rule of law review cycle and a series of other international elements, elements related to the issue. Now, this is going to be the most powerful pan-European monitoring of fundamental values because it's going to have the real power to affect the budgets of states. As I think even if it doesn't do that, it doesn't actually lead to punitive measures financially, it's going to have a huge influence. So what's it got to do with the European Court of Human Rights? Now, the Strasbourg Court is the oldest and most important institution in the continent to counter authoritarianism and protect the fundamental values. Non-implementation of its judgments is fundamentally a rule of law issue inherently, for obvious reasons in terms of non-implementation of a judgment. But it's also important to mention the content of the judgments themselves. It's a serious sign that the values that underpin the rule of law are being threatened if these judgments are not being implemented. Now, in the rule of law procedure at the moment, non-implementation of ECHR judgments is mentioned, but only in cases concerning independence of the judiciary, length of judicial proceedings, and also some media-related cases, particularly defamation. Now, so for example, for the Hungary chapter, there's only 3 out of 53 of the pending leading judgments referred to, and Romania, it's only 4 out of 84. Now, it doesn't take into account, in particular, systemic non-implementation of ECHR judgments. So there's some countries mentioned there, but there's actually many others, I think, have quite a surprisingly high level of non-implementation of leading cases. And 30% of leading judgments against EU countries overall from the last 10 years are still pending. So I think it's important to say that a lot of these cases concern issues that are really fundamental to democratic backsliding and the rule of law. Currently, we're in an anomalous situation where EU states don't have to be signatories to the ECHR. They do need to be signatories to the ECHR, but they don't actually need to implement judgments. And indeed, they face no repercussions with the EU monitoring processes if they don't implement judgments. The Luxembourg court, it's important to say, has jurisdiction over a number of important issues to the rule of law and democratic backsliding, but not all of them. The Strasbourg court does, and that's why implementation of ECHR judgments is fundamental to addressing the continent's governance issues. So our recommendation is for all actors in the sphere, so that's governments, institutions, and also civil society, to promote the idea that the EU rule of law review procedure and the budget conditionality assessment should take into account the systemic non-implementation of ECHR judgments. It'll be really important part of an effective rule of law review. It'll have the benefit of enhancing ECHR implementation. There's been a lot of increased cooperation from the Council of Europe and the EU recently, and it's a natural progression of that. It is feasible. I think I've had conversations with the Secretariat members of the EU in Brussels, and it's an open idea that they're willing to consider. So I think it's really worth pushing. It's important to say that accession by the EU is also to the ECHR is not necessary. The EU can choose to do this unilaterally as part of its own processes, and that is part of an ongoing advocacy campaign by European Implementation Network and also Democracy Reporting International. And we'll be doing more work over that over the coming year. I don't really have time to go into much detail about
you don't have time to, sorry, I'm going to have to cut you off.
I'll skip this, Claire. Let me finalize just by concluding. This isn't a comprehensive set of ideas. Once again, lots of these could already be under discussion, already dismissed, already being taken up by different actors. But it is, I hope, interesting food for thought just from the perspective of civil society. I'll conclude by saying events like this really demonstrate a strong level of concern about implementation by those wishing to protect the system. We hope that's going to translate into long-term systemic solutions that are needed. And indeed, that will require a lot of political and financial investment, but hopefully it will happen, and I really think it will be worth it. Don't hesitate to get in touch if you'd like to discuss these issues more. That's it from me. Thank you very much. Claire.
Thank you very much, George, and hopefully we can have more discussion afterwards at the end of this panel. So it's very interesting that we're already moving into some very interesting ideas for solutions for this problem, both in terms of building capacity at national level, particularly with civil society, and also this very interesting idea of using the European Union rule of law procedure to really put a bit more pressure on states to execute the court's judgments. So my final panelist, I'm delighted to invite Veronica Fikfak to take the floor. Veronica is an associate professor at the Copenhagen University I Courts. Veronica.
Super, thank you very much, Claire. And thank you, Bashak and Philip, for inviting me. So I asked to really speak last in this panel because I felt that the paper that I'm going to give, it's sort of a link between what I've called justice delayed, justice denied. So execution delayed, execution denied. So I'm in charge of a 5-year project where we're trying to understand what motivates states to comply with decisions of the European Court of Human Rights, what motivates them to change their behavior and really put in place different processes and practices within their country to sort of internalize ECHR case law. And so we're looking at when states comply and when they execute judgments. But today I wanted to talk about sort of an aspect that we don't really associate with compliance, and that's the really practice of friendly settlements. Now, when I started doing my 5-year project, I was looking at this large database that our first speaker talked about, right? This large database of case law. But I was also wondering what in this 25,000 cases that we have, what is it I wasn't seeing, right? And when you look at the ECHR case law a bit more closely, you realize that there are all these decisions rendered by the court that actually represent a friendly settlement. And I call friendly settlement groups really the black hole of the ECHR case law, because for the most part, these cases would be cases that would have ended up in a violation, but for the settlement process. And instead, where we find them is we find them under struck out decisions, where usually they don't really get to be tackled or analyzed. But I think it's important to think of settlements in terms of what their function is, but also what they deprive us of, right? So when you think about settlements, it means that we don't get a judgment at the end. We don't get a reasoning from the court of what happened and what kind of violation took place. But we also don't get the benefit of the development of human rights law or the clarification of what that law is. I think even more importantly, what we don't get is we don't get this understanding of what the country's record is. So this settlements don't appear on any report card in relation to any country. And so we don't know of all of the problems that could exist or that do exist in specific countries. And the state doesn't have a meaningful opportunity really to address them in a systemic way, or really we don't give it the opportunity to get the supervision that it would in terms of trying to fix the problem internally. So when we study compliance, and when I think about compliance and execution, I'm really thinking about not just sort of ticking the boxes, but achieving long-term justice, right? we also have to study, I think, friendly settlements, right? And we need to study those settlements both from the perspective of the individual victim and what kind of justice they deserve, in terms of the state, right? And what kind of an opportunity the state deserves to really achieve long-term change within its borders. And thirdly, we need to think about it from the perspective of human rights law more generally. So from my perspective, execution and compliance is really about change in behavior in the Council of Europe states. So what I want to do today is really sort of think about how big this friendly settlement or the black hole is. And then I want to think about how it works for the three sort of subjects that I mentioned, for the victim, for the state, and then for the human rights law more generally. So I'm going to share a graph with you just to show you how big that is. I hope that's visible, is it? Yeah, super, thank you. So on this graph on the left, you see what I've done is I've essentially mapped out in gray all the cases in which there was a violation per year. And then in red, you have next to it, like all the cases of friendly settlements and unilateral declarations. And I think I wanted to put them one next to each other first for you to see how they compare. But because effectively friendly settlements and unilateral declarations are cases in which there would have been a violation, I think the right graph is the more appropriate graph for us to look at, right? And what you really see on the top of that gray mountain, which is the violations found by the European Court of Human Rights, is that really big red chunk or kind of a cap, right? That represents the friendly settlements. So those are the cases that would have been, but are not. And it's actually quite a big, right, big black hole. And so for me, the question is, what does this achieve? Because per se, friendly settlements are not, let's say, a bad thing, right? So when we think about settlements, we think about two neighbors fighting over a wall. But in reality, most of the time, settlements, and this is research coming from 1980s, settlements happen between an individual that has low resources, low information, little knowledge, and a governmental organ, or in our case, between a state, right? And so there's this imbalance of power, if you think about it, right, between our applicant and between the state, imbalance of power where one party has unlimited resources, information, and knowledge. And in order for settlement really to take place between these two parties, right, where something has gone wrong, we need a third person to come in. And in the Inter-American Court of Human Rights, the way they've really dealt with settlement is that they've thought about what is the goal of settlement, right? If we're going to privatize this dispute, it is very important that we give the parties what they deserve. And so in the Inter-American system, what will happen is that you will get the commission, sort of a third party, coming into this relationship and really helping the two parties sit together, discuss the issue, but also giving this individual, our individual who's tiny, right? Giving them a level playing field to really be able to position themselves vis-a-vis the state, to be able to air their grievances, to negotiate really creatively the different remedies that they need, and to reestablish this relationship that has been difficult and has led to a number of violations. So the argument in the Inter-American system is that if we are going to take away from litigation, from adjudication, this dispute, it needs to bring something to the individual victim. And the question is, does this happen in the ECHR context? And in the ECHR context, settlement takes place really with the help of the registry. So we have a third party. But because there's such a workload, this dispute is not a dispute where the two parties would actually meet, but it's an entirely written process where the registry takes charge of the communication with the parties, right? And what the registry will do, they will send this letter to both of the parties and say that they think that the case is suitable for settlement, And they will also attach a letter in which they will say essentially what the payment should be, and that you only need to sign as a victim and sort of accept this settlement offer, right? Now, when I spoke to lawyers about how their clients feel when they receive this letter, what they told me is that essentially this message of your case is suitable for settlement gives them a feeling that their case is actually not suitable for a merits assessment, that their case is not good enough. But in addition to this sort of written type of communication, there's an additional element that happens. And that's that in addition to the settlement that we have that can be achieved between our applicant and the state, there is also the threat that sort of hovers over the relationship, the threat of a unilateral declaration, right? Where effectively consent of our applicant is not needed and the state can effectively impose its declaration or the closure of a case onto the applicant. So what we see from this process is, when I'm thinking about what justice is achieved, right, is that the victim is really not at the center of the consideration of the process. So then if I move on to the state and thinking about the state and what the process does for the state in terms of long-term justice, the question is really, does the state get this opportunity to redress its wrongs? And I'm being sort of generous in how I put this, right? So, the practice is obviously raises issues about how it facilitates certain states to develop skills of negotiation, right? And let me be more specific. Countries will have different cultures of settlement. Some will refuse settlement altogether, but there will be countries, and there are countries that effectively settle as many cases as they lose in the European Court of Human Rights. And I've got a graph essentially that shows that Hungary, Poland, Serbia effectively double their case law through the cases that they settle. And so, but we're also seeing, when you look at this case law, is we're also seeing certain countries that settle only specific types of cases, for example, asylum and refugee cases, so that they don't appear on any report card anywhere. Now, what's interesting is when you speak to state representatives about how they see the settlement process, is that they will often talk about people in the registry, us helping them, really us forming a partnership with them. They will speak about this relationship of trust and confidence that has developed between them and the registry. And they will talk about the mutual understanding and the comprehensive discussions they're having with the registry about what will make the court accept our unilateral declaration or our settlement so that these cases effectively go away. So for me, the question then was, okay, if there's this cooperation in terms of reducing the workload that actually works for the state, what is being agreed in these settlements, right? So what are the remedies that the state is being asked to undertake? Could those potentially be leading to long-term justice? In the Inter-American Court of Human Rights, Jorge Conteste writes about how the remedies agreed in settlement are equally creative as the judgments, and that they are implemented to an equal or even better degree. And so I looked at that, and what's become very clear is that in friendly settlement cases, in about 95% of those cases, we are seeing the remedy being exclusively monetary. Now, the problem is that often you actually won't be able to call that a remedy, you won't be able to call it compensation or damages, because there is no recognition of a violation. So effectively, those are ex gratia payments made by the state to have the cases go away. It is exceedingly rare, if I take it a step further, to see in these cases a remedy agreed that is not monetary or that is in addition to the monetary remedy. So those are the sort of decisions of settlements with an undertaking. And here, Philip has, you know, a lot of experience on trying to agree the requirement of investigation in relation to certain countries to undertake an investigation in their in response to an alleged violation that has been settled. Now, the problem there is that from what we have seen is that there is no to very little follow-up or enforcement about what happens, because there's really very little being done beyond checking if the money has been paid. And so the question then is, can you go to the court and ask for the case to be reopened? And there seems to be very little sort of desire to do so. Philip wrote a blog on Strasbourg Observers where he talks about being sort of sent a letter back saying, please don't contact us effectively because we won't be able to answer you because we've got too big a workload, when they requested for a case to be reopened because effectively Georgia had refused to implement the requirement of investigation that it had agreed in a settlement for a number of years. And so if we have then this relationship where the state is not really expected to do much apart from paying, there's really a problem in terms of achieving long-term justice. And that really then gets me to the third point, which is the idea of what does it do for human rights law, this process that we have adopted. So I think it's important for us to think about human rights litigation as a public good, right? And so it benefits not only the victim, it benefits the state, but it also benefits us and it benefits other states who could preventatively adopt certain measures within their own system to fix problems that they didn't realize that they had. And the argument thus far has been that settlements are allowed only in repetitive cases, and so that there's no issue in terms of creation of new human rights law. But speaking to lawyers, they have actually expressed concerns that settlements are now being, obviously as a rule, encouraged even in cases where there's been torture or loss of lives, but I think more importantly also in cases that open up new legal questions, whether or not those are questions relating to systemic violations within a specific country, or whether or not they're new legal questions more generally. And so effectively what this settlement process deprives us of is knowing what the problems are. So we can't even talk about compliance or implementation if there's a black hole and we don't know about it. We can't learn from it. So effectively, I think from my perspective, the way the process has been set up, and I think it's important to underline that since 2019, settlement has now become an integral part of the process in front of the European Court of Human Rights, and the first 12 weeks of any applications are dedicated to that. But the way I see it is that if we're thinking about what the aim of any judgment is, to help the victim, to sort of give the state the opportunity to fix a problem, but also to aid us all in terms of clarification of human rights law, I feel that that big red cap that you saw deprives us of having the benefit of that. So although there's a famous scholar who said in relation to settlements that although dockets are trimmed through settlement, it is hard to see justice being done. And I think that is the case in the context of the sort of the process or the practice that has developed in relation to settlements in the European Court of Human Rights. So I would very much neither encourage nor praise the settlement process there. So I'll stop there. Thank you very much.
Thank you very much, Veronica. So now we have some time for questions. So I encourage everyone who's online to either ask for the floor by raising your hand using the raise hand function on the Zoom, or to give us some questions using the Q&A button. So actually, I mean, my first question actually is to Veronica, because I listened very interestedly to what you've been saying, because we also in the department have, especially when the court did make this more of a sort of systematic process, the idea of friendly settlements, we were quite worried that we would lose interesting precedent cases. But according to the registry guidelines, they're not supposed to be settling cases which raise new issues or where just kind of human rights requires that the case should not be settled. So I just wondered, and I found it quite alarming what you were saying, that you anecdotally at least, that you found that this was not strictly being observed. And I just wondered if you'd done more kind of detailed research into the types of cases where they're not repetitive cases that are being settled.
Yeah, thank you very much. So from speaking to lawyers, one of the things that they sort of raise as a concern is that settlement is effectively being encouraged before the registry has had, or the person working on the case has had the opportunity to look at the merits of the case. And so in certain circumstances, this is what I'm getting from interviews, in certain circumstances, it is problematic to know unless the lawyer spells it out for you or underlines it and fights it, how the case raises a novel question and in what way it does. And so I think what it reveals is that there's a very big sort of weight and expectation on the lawyer to be very explicit, in advising their client not to settle, but also then to fight it vis-a-vis the court, that the case is not. And so in some sense, the whole process relies on repeat and excellent and, lawyers that have experience. But someone coming out of for the first time turning to the court is going to have it very difficult to refuse when they don't know how things work. And so you need to be very confident, I think, to do that. But in terms of the types of cases we have seen being settled, there's actually, I think we were surprised that there's actually been quite a bit of increase on Article 2 and Article 3 cases. Which, even Helen Keller, when she wrote her big book on friendly settlement, raised the issue of should those cases ever be settled. So you sort of get, because the settlement decisions only contain sort of a summary of what the allegation was and then what was agreed, it is in some sense for an outsider impossible to know, unless they speak to lawyers, whether or not the case raises a novel question. So we are in a state of ignorance about how many of those cases might be going through.
Welcome to our second panel. For those of you who may have just joined us, maybe it's helpful to indicate that the panels and the sessions are being recorded. There's going to be a discussion and a Q&A session, and we would invite you to use the Q&A function at the bottom rather than the chat function of the Zoom. And also you can raise your hands, and Davide Paris, our chair, may then be able to give you the floor. So over to you, Davide, and thank you very much for chairing the second panel on deficient execution.
Thank you, Başak. Thanks the organizer for inviting me. I'm delighted to chair this panel on deficient execution. And as a brief introduction from my side, I think that the three presentations and our discussion will turn around three main issues, three main points. First, exploring and mapping deficient execution. What is deficient execution and how can we define it? How frequently does it happen? How many cases can be considered cases of deficient execution? Which cases or types of cases are more likely not to be fully complied with by the states? And what are the causes thereof? To what extent are states unwilling to fully comply, and to what extent are they unable to fully comply? Second, the perspective of the states. What could and should be done at the national level to avoid and to overcome deficient execution? To what extent can a solid institutional and constitutional setting or specific legal arrangements help overcoming the lack of political will to comply? And what role can play different domestic actors, both institutional actors, governments, parliaments, the courts, but also NGOs and civil society organizations, in line with what we have already discussed in the previous panel. And third, finally, the perspective of the Committee of Ministers. How should the Committee of Ministers deal with cases of deficient compliance? Which strategy will prove successful in the short and in the long term? So we have the privilege to discuss all these questions and more with three prominent experts and scholars who have worked and written extensively on the execution of the ACT-HR judgments. Each of them is expected to give a 15-minute talk, and it will be my unpleasant duty to remind you to respect this strict time limit so that then we can have a fruitful discussion. Our first speaker is Andreas von Staden. Andreas is an assistant professor of political science at the University of Hamburg, and he will speak about the art of possible on the interaction of law and politics in minimalist compliance with ACT-HR judgments. Thank you, Andreas. The floor is yours.
Thank you very much for the invitation, for the introduction. I'm very glad to be able to revisit and recap earlier work on minimalist compliance. I'm sharing my screen with you now, and I apologize for the very skeletal nature scared of the slides. There were some unexpected time constraints I had last week, so I could not prepare anything more elaborate. Let me start by saying that the research into minimalist compliance that I did took its cue from assertions that were prevalent in the 1990s, that compliance with the judgments of the European Court of Human Rights was virtually perfect. Already, of course, by the early 2000s, it was clear that this assertion could no longer be maintained in an unqualified fashion. But even if it was true, at least with respect to the established genuine liberal democracies in the system, it left unaddressed the quality of compliance in terms of its scope and its depth. Compliance standards, after all, are not objective givens, but are set and often negotiated by actors with certain interests and preferences of their own. In many instances, states have different options as to how to meet these standards, options whose differences will often turn out to be consequential. The choice amongst these options, I argue, is conditioned mostly by cost-benefit calculations, resulting in what I have termed rational choice with a normative constraint. The normative constraint is the obligation to comply with a judgment. And that will often, so the expectation, result in minimalist compliance. Now, minimalist compliance presupposes choice. If the remedy is specified ex ante and does not allow for a substantive adjustment, then the only question is whether to comply, not how to comply. That, of course, is the case of just satisfaction, where the amount set by the court has to be paid in full and cannot be changed by respondent states. But the situation is frequently different in the case of individual and especially general measures, where respondent states often face a certain spectrum of feasible alternatives that arguably remedy the violation to some extent at least, but do so differently and in a different manner. Here the question then becomes what the minimum threshold is that needs to be crossed for a remedial response to be considered compliant. The expectation behind minimalist compliance is that states will seek to do just as much as is needed to make them compliant, but rarely more. This may then formally end the supervisory process before the Committee of Ministers, but it has consequences for the scope of rights protection, as well as for the convention control machinery as a whole. I'll address those at the end. Why should we expect minimalist compliance as the baseline expectation, rather than expecting responses that will seek to maximize rights enjoyment after an adverse judgment? Simply because minimalism is often the rational choice for most states, at least in the short term. There are cases where there's preferences and incentives at play for a broader, deeper compliance, not only with the judgments and conventions letter, but also with its spirit, one might say. But these cases are the exception, not the rule, and thus do not function well as a baseline expectation. Why the preference for minimalist compliance? Well, for respondent states, an adverse judgment requires a change in behavior that such states would, in most cases, not have undertaken in the absence of the judgment. If the respondent state actually had a preference for a change in the direction of a given judgment, then it could have done any such change at any time along the way, right? After the lodging of the complaint, after pleadings, and so forth. The fact that a state defends its position at issue in the case until the end, and possibly even thereafter, can in most cases be taken, if not necessarily as a preference for the substantive status quo, then at least as a preference against change. And any such change is costly, right? Materially and or politically. Some more so, some less. But if there's no genuine preference in the direction of that change to begin with, then we should expect that respondent states will seek to achieve the objective of compliance in a version of the economic min-max principle at the lowest possible cost, either in terms of material political costs incurred or in terms of sovereignty costs, that is, restraints on their ability to act as they see fit. Political costs may in particular be incurred in light of the fact that the structural nature of human rights complaints commonly puts members of some political minority or politically underrepresented group against the political majority. In such situations, office holders do not generally benefit by granting the applicant or the group to which he or she belongs more or greater rights than absolutely necessary. In addition, when judgment execution involves the political branches of government, the limited time horizons of office holders will usually argue against incurring unnecessary costs for which one is not being rewarded at the ballot box or some other type of evaluation. Reducing costs for one's potential successors by incurring extra costs today is not a particularly promising or attractive strategy. It makes more sense to let future decision makers deal with future consequences, even if that decision maker turns out to be oneself again. Last but not least, while decision makers' compliance calculations could be tweaked through meaningful enforcement and or sanctioning or conditional incentives, benefits, that is the imposition of costs, in favor of broader, deeper compliance, such instances of observable enforcement domestically or internationally are far and in between, in particular in established democracies, the ones certainly that I have studied, but also others about which I've heard. So let me give you some brief examples of what I mean by minimalist compliance, coming from Italy, Scotland, and the UK as a whole. Regarding Italy, one reason for the large number of Italian length of proceedings complaints in the 1990s and early 2000s had been the lack of a domestic legal basis to claim compensation for damages suffered as a result of lengthy proceedings at the national level. Italy eventually remedied the situation with the adoption of the Pinto Act in 2001, which, among other things, established the entitlement to compensation for anyone sustaining pecuniary or non-pecuniary damages as a result of unduly long proceedings. And while reducing the number of applications to the European Court of Human Rights, it evinced shortcomings that should suggest clearly that lawmakers at the time desired to limit the effect of the law on Italy's coffers, its financial resources. For example, the 2001 Pinto Act specifically limited compensation to pecuniary and non-pecuniary damages that had actually been incurred. Now, before the European Court of Human Rights, you also had to prove pecuniary damages, but the award of non-pecuniary damages followed automatically from the fact that the excessive length of proceedings did cause uncertainty, psychic stress, and so forth. In Italy, under the Pinto law, the first version, you had to prove that these actually existed. The Pinto Act also fixed the annual amount available for disbursement, initially at 6.5 million euros, an amount that roughly equaled what Italy had paid in 1999 in these cases before the European Court of Human Rights. But since the number of applications had increased since then, this meant that the funds would either be depleted before everyone could be paid out, or the domestically awarded amounts would have to be lower than those awarded by the European Court of Human Rights. The provision indeed appeared to be a political concession to the Parliamentary Finance Committee, which had advised against the Pinto Act at the bill stage precisely because of its expected financial implications, exacerbated by the indeed well-founded expectation that compensatory relief would be applied for in even greater numbers now that the remedy was available domestically. And indeed, as regards subsequent judicial practice, average amounts awarded to claimants were about half of what had been awarded by the European Court of Human Rights, and in some cases as low as 8%. So this led then to follow-up litigation with regard to that practice, that domestic practice, and the Pinto Act. And then in 2006, the Grand Chamber put that case to rest by declaring that the practice was a violation itself because it did not follow with the established practice of the European Court. Second case, Scotland, legal aid for criminal appeals. This is an earlier judgment from 1990. It relates to an earlier judgment where the court held that Scottish legal aid schemes for criminal appeals violated the fairness requirement under Article 6.1 due to the fact that the Scottish Legal Aid Board would grant aid only if it found that there were substantial grounds for making the appeal. There's some substantive assessment. The government then first thought to comply by way of a practice notice advising appeals courts that they should adjourn proceedings ex officio and make representations to the Legal Aid Board to review its decision denying assistance if they found that the issues at stake were such that assistance was merited. These assessments, of course, were again subject to discretion and varying opinions, and the European Court soon took issue with that manner in which the guidance note had fared and declared it to be a violation, a continuing violation still, because the original violation was not remedied. Now, in response to that judgment, the UK did, or Scotland did then comply and indeed provided for legal aid in all criminal appeals proceedings on the sole basis, in most cases, of financial eligibility, financial need. But at the same time, it also abolished the previously automatic right to appeal and made it subject to the requirement of first having to seek leave to appeal. So it replaced one barrier with another. And at the time, there was no jurisprudence that said you had to provide for automatic appeal. So formally compliant, but still trying to limit the impact on the system. Last but not least, UK prisoner voting rights. That saga finally came to a formal end at the Council of Europe in December 2018, when the Committee of Ministers adopted its final resolution on the first Hertie the Hertie number 2 cases and related judgments, noting in a standard phrase in its final resolutions that all measures required by Article 46 had now been adopted. But is that so? I have detailed this in a contribution to the ECHR blog, the position that this is hardly the case, right? As you all know, the court had taken issue with the blanket voting ban for prisoners enshrined in Section 3 of the UK's Representation of the People Act from 1983 and already existing in earlier versions of the law. Importantly, in all prisoner voting rights cases, the court linked the violation specifically to its legislative source, noting in no unclear terms in the subsequent pilot judgment of Greens and MT that, and I quote, "It is clear that legislative amendment is required in order to render the electoral law compatible with the requirements of the convention, and that the respondent state must introduce legislative proposals to amend Section 3 of the 1983 Act with a view to the enactment of an electoral law to achieve compliance with the court's judgment in Hertie and others." The UK, of course, did nothing of that sort. You all know, opposition to the call for changes was strong in both major parties as well as in the population at large. And the eventual solution on the basis of which the case was closed indeed pushes the boundaries for acceptable minimalist compliance. Rather than change the law, the UK adopted administrative measures that enabled those prisoners released on license or on home detention curfew to vote. And The Guardian, the newspaper at the time, estimated that these changes would benefit about 100 people. These remedies stayed well behind other alternative proposals that were discussed along the way that would have enfranchised those with prison sentences of 12 months or less or 6 months or less. Notably, these changes would not have prevented any of the court's findings of a convention violation because they are related to prisoners actually in prison and not on license and not under home curfew. So the most surprising aspect here is not really that the UK took that decision given the domestic preferences, but that the Committee of Ministers found it to be sufficient to close the case. Now, there's many other examples, and I look in my book, I only look at Germany and the UK, but I know from discussions with others that in other countries, this phenomenon is also observable. And there's certain implications that this has. And I just want to mention 3 of these. One is inefficiency. For those implementing remedies to achieve compliance, minimalist compliance may be effective in lowering short-term compliance costs, political, material, sovereignty costs. But it also leads to a degree of inefficiency of the ACHR control system as a whole, as it often creates avoidable costs downstream by way of subsequent litigation about issues that could already have been addressed and eliminated as sources of convention violations as part of complying with earlier judgments. As in the tragedy of the commons, you find a situation where individually rational behavior can thus lead to systemically suboptimal outcomes. certainly in economic terms. Second point, democratic legitimacy. In the book, I argue that as unsatisfactory as minimalism and its effects may be, it could be that this is simply the result one has to accept of balancing the authority of two types of actors. The European Court of Human Rights on the one hand, governments of states subject to its jurisdiction on the other, each of which has its own defensible claim to democratic legitimacy. In many cases, the court's positions, however principled they may be, are not the only correct or defensible ones that a reasonable interpreter of the convention would necessarily have to arrive at. Allowing states some margin of appreciation within which to give such decisions effect domestically and form that response in light of the preferences of domestic majorities can itself be seen, within limits certainly, as a normatively appropriate balancing of the decision-making of two legitimate sides of political and legal authority. Any inefficiency resulting from minimalist compliance is then simply the cost that we may have to accept as part of operating a system, a governance system in which such actors negotiate over time and through indeed repeated interaction the appropriate relationship and balance between majority preferences and the human rights interests of individuals and political minorities. Last but not least, human rights regression. In a recent E-journal article, Larry Helfer and Eric Witten argue that there are indications that the court's own Grand Chamber had begun to walk back human rights in Europe, the title of the article, especially in cases against consolidated democracies and after 2012, the year of the Brighton Declaration, evidenced in particular by the post-Brighton rise of walking back dissents in which members of the court themselves critique the majority position. To the extent that the Committee of Ministers' posture with respect to the Hearst judgment is reflective of a more general practice to cut states some slack and to allow them to push down on the compliance threshold. And I have to admit that I have not systematically followed the committee's practice over the most recent years. Then minimalist compliance and its acceptance as sufficient may contribute indeed to the phenomenon of walking back rights in Europe. And I come to the end by noting that minimalist compliance is, for the most part, and the Hearst case may be an exception, not in a strict sense deficient execution, at least not formally. After all, minimalist compliance does involve the implementation of remedial measures and meets the compliance standard articulated for a given violation or case type at a given point in time. If you consider at least certain instances of minimalist compliance as deficient execution from a broader normative point of view, then the real deficiency concerns the applied standards that permit such forms of execution to be qualified as compliant. Standards that I noted at the very beginning are themselves the endogenous result of a political process at the Council of Europe, and that would need to be changed through that process if that were desired. Thank you.
Thank you, Andreas, for this very clear and very thought-provoking presentation. It raised many questions in me, and I'm sure also in our participants. There is already one hand and one question in the chat, but let's keep the question for later. I give the floor to our second panelist, Alice Donald, Senior Lecturer at the Department of Law and Politics at Middlesex University, for a presentation on the domestic ecosystem of implementation, how Council of Europe bodies can cultivate compliance partners. Thank you, Alice, and the floor is yours.
Thank you very much, David, and thanks, Andreas, also for your stimulating presentation. And we have a hard act to follow also from the first panel this morning. So yeah, I want to talk about implementation of judgments, starting with a sort of metaphorical approach regarding it as a kind of ecosystem, and I'll explain why. I'll then quickly look at what we might recognize as deficient execution, some of the patterns, the causes, and a case example or two of deficient execution. And then I want to borrow this term, which was first coined by Alex Huneeus in the context of the Inter-American system, of so-called compliance partners. And I've got some suggestions for how the European system, the Committee of Ministers in particular, can go about cultivating compliance partners at the domestic level. So to see implementation as an ecosystem, forgive the graphic here, we have a dictionary definition there, but the second one down is perhaps more relevant for us: a complex network or interconnected system and taking place within a specific environment. And I think this is quite a helpful way to conceive of implementation. In other words, that I think that where scholarship is now, and I'm drawing here both from legal and political science scholarship, as has already been mentioned today, doesn't see either the court in issuing judgments or the Committee of Ministers in its role in the supervision process, or indeed the involvement of other Council of Europe actors such as the Parliamentary Assembly, the Commissioner and so on, as sitting, if you like, above the domestic system, that this is not a kind of unilinear or hierarchical system. Rather, there is a much more porous boundary than that would suggest between the domestic politics and the supranational level, which makes the implementation process then much more dynamic, much more iterative, and to some extent also unpredictable. So we're not thinking of judgments or supervision being, as it were, handed down to a monolithic entity we might call the state. Rather, what I suggest, and here we're moving to a more industrial metaphor perhaps, is to think about implementation in terms of its moving parts, interactions which may take the form at different moments of negotiation, collaboration, bargaining, contestation perhaps, at the domestic level with the different actors of the state, the executive, of course, the parliament, judiciary, and also, and we've heard this, of course, very much from George Stafford in the first panel, of non-state actors, of civil society in all its forms, and obviously also national human rights institutions, as well as that relationship between all those domestic actors and the supranational level. So really just to emphasize the dynamic nature of this process. Here what I've captured are some patterns really from my own research and research carried out with Philip Leach and others on this call, also qualitative research into human rights implementation, as well as the quantitative work also that Oyvind set out so well for us this morning. Oyvind mentioned already the first one. This is, I think, a very well-established finding now, that the more actors that are involved in implementation, the less likely, or at least the slower, compliance is. So I can give an example here. For example, one of the cases we've researched in some depth in Belgium to do with chronically poor prison conditions in violation of Article 3 of the Convention. There, it took the very conscientious government agent's office 6 months just to identify the people that needed to be involved in this process in different ministries and at different levels of government in Belgium. So the plurality of actors is a factor, and this has also been established not just in Europe, but research in the inter-American system. Then the types of cases which tend to have slower or deficient execution, certainly there's a pattern of cases that require investigation and punishment and accountability are more poorly implemented. And again, I've got a quote from Alex Huneeus as to some of the reasons for that. Also, cases involving systemic discrimination seem to be particularly hard to implement, and indeed the even identifying implementation of those cases, I think, can be difficult, and I'll give an example of that in a minute. It's already been mentioned the importance of having well-resourced and coordinating structures, classically the government agent's office in the European context, with sufficient political influence within the government apparatus. But I think what research reveals also is that particular judgments, even within a fairly well-functioning system, can have perceived political or normative costs attached to them that can prove a barrier in these particular cases. And also that even well-intentioned conscientious national authorities may not be in complete control of what happens. So the levers of reform may be pulled, if you like, but may backfire or have unintended consequences. So I think we can't necessarily assume that the authorities are necessarily, as it were, controlling all the events that happen in the execution process. We've been asked to focus on deficient execution, and I just wanted to mention, of course, that there are some very good news stories as well, including states that exceed the requirements of the judgment, but I just wanted to note that for some balance. Now, I'm giving here an example of one particular judgment, Identibur versus Georgia. And this is a case that many of you may know that concerns homophobic and transphobic hate crime in Georgia, stemming from an incident in 2013, the judgment was 2015, of an attack, religiously motivated attack on a group of LGBT protesters in Tbilisi. And this was found to be in violation not only of the right to freedom of peaceful assembly, but also inhuman or degrading treatment under Article 3. We've tracked the implementation, or indeed non-implementation so far, of this judgment over some years now. It is still pending before the Committee of Ministers under enhanced supervision. And what I've done here is just to try and break down what I think deficient execution looks like in this case. So it is not the case that Georgia hasn't engaged with the Committee of Ministers. There was some delay at the beginning, but there have since been quite a number of action plans, and indeed 3 action reports submitted to the CM. In other words, 3 times Georgia has tried to convince the CM that enough had been done to close the case. Each time the Committee of Ministers has said no, and that has been partly on the strength of some excellent Rule 9 submissions by groups of NGOs and the Public Defender, the National Human Rights Institution. So what we see here then is not only repetition of the violation, even worse violence, in fact, meted out in subsequent years, or the this annual event that was originally attacked being cancelled for fear of being assaulted in the street. We have also got records of harassment of victims and witnesses and failure to investigate the original incident. Some progress has been made. So, for example, one of the calls of the Committee of Ministers was for disaggregated data to be collected on hate crimes, which does now happen. But the NGO submissions make clear that there is still huge underreporting of homophobic and transphobic hate crimes because of fear. Training of law enforcers in quite significant numbers, but again, the NGO evidence suggests that the quality of that training and its efficacy is in doubt. Just to pick the middle one at the bottom there has been a specific proposal that originated from the Council of Europe's equality body, ECRI, which has been picked up by NGOs and much more recently by the Committee of Ministers itself, for a specialised police hate crimes unit to be established. And so far the government has rejected that. So there I think we see deficient execution in action, some activity, but by no means enough. So turning back to this idea of compliance partners, and this, as I've tried to convey here, this sort of dynamic relationship between them, which means that we need to be interested both in the institutional design and the working methods of supranational bodies, in our case, the Committee of Ministers in particular, as well as the characteristics of the state itself and the system or lack of system for domestic implementation. We've also seen interesting examples of the importance of individual agency within those structures, that certain, at certain times, certain key individuals can actually unlock a degree of progress with implementation. And I think also the particularities of each case, that certainly for complex cases, what seems to be the case is that in a sense, each has its own trajectory. So to give you one example there, the foot dragging we've seen on the Identaba case has taken place simultaneously with very effective and impressive implementation of another judgment from the Strasbourg court relating to healthcare in prisons, in which the Georgian authorities actually well exceeded what was strictly required by the judgment. So this was not about resistance to Strasbourg as such, that those two groups of cases in fact took completely different trajectories at the same time. So just a quick word on the context in which I think we need to understand implementation. Again, focusing particularly on these complex cases requiring sometimes multiple general measures. Whenever you start to sort of dig a little bit under the surface, I think what becomes clear is the need to reach back in time to understand some of the barriers to implementation. So to return to the Belgian prisons case, Vasilescu, that I mentioned earlier, in talking to people about that case in Belgium, they were actually reaching back decades to understand why it is that the Belgian criminal justice system has seemed to result in overcrowding in this very dilapidated prison stock. We've also tracked, and I'll mention this again in a minute, the case of DH versus the Czech Republic concerning systemic discrimination against Roma pupils in schools in Czechia. And again, a whole mixture of institutional and attitudinal barriers there, which has caused progress to sometimes be completely frozen for some years. And I think here we have to pay tribute in a way to the persistence, the sheer persistence of the Committee of Ministers process that keeps judgments on its book and returns to them in some cases year after year, as Claire was mentioning in the first panel. What can happen, I think, is also that there are moments in the execution process, particularly these prolonged processes, where perhaps for reasons that are nothing to do with the judgment, moments of opportunity or doors of opportunity open or indeed close. And I think that's also part of understanding this very dynamic process of implementation. And a mention again of the importance of there being stable domestic structures sufficiently resourced, the benefits they bring of providing continuity and institutional memory at the domestic level, bringing in other players, and also guarding against the sort of over-politicization of implementation. Not that it should be reduced to a purely technocratic process, but and this was said to us by colleagues in the government agent's office in the Belgian context, that they see themselves to some extent as a kind of technocratic hand on the tiller, if you like, particularly for very contested cases. This is just a snapshot, and it doesn't capture the fluidity over time, really, of the complexity of this ecosystem, if you like, of the pro and anti-compliance actors in relation to the DH judgment. I'm not going to dwell on this too much because I'm conscious of time, but you can see there that the pro-compliance actors on the left, those who have opposed it on the right, quite a complex sort of constellation of actors on each side, which indeed have also changed over time. Pro-reform education ministers have come and gone, and so on. And this slide captures some of the behavior, if you like, and the points on the left then are again trying to capture this concept of deficient execution, and on the right some of the strategies that we've identified pro-compliance actors as using. So on the left you can see from outright harassment, as we've seen in the Identiva case, failure to protect victims or the wider beneficiary group, and various sorts of obfuscation, really, sometimes dressing up actions as implementation, which in fact are not, or which are only superficially so, and sometimes overt blocking of reform. And then quite a wide variety of pro-compliance strategies on the right-hand side, alliance building, careful framing of issues to depoliticize them. This is very relevant to the DH case that I've just mentioned. Sometimes accentuating and sometimes downplaying the Strasbourg origin of the reform that is required. And just to pick one also near the bottom there, we've seen also conscientious pro-compliance actors, thinking here particularly of a deputy education minister in the Czech Republic on the DH case, realizing that the political space wasn't there and deliberately delaying or limiting the ambition of reform. So, for example, in this case, sufficing with executive orders rather than seeking legislative reform at a time when they knew they wouldn't get it through Parliament. So some quite interesting strategies at the domestic level. And finally, I just want to point to some priorities suggested by all these findings, and I think all of these have actually been mentioned already. So starting with the design and the working methods of the Committee of Ministers process, and the onus on the CM, which I think indeed it recognises now, to pull in information and evidence from diverse sources, including victims themselves, civil society organisations and national human rights institutions. So I calculated this, that victims have so far made submissions to the CM in only about 3% of all judgments. not a much higher percentage still overall for NGOs and national human rights institutions, but crucially that number is growing. So you see the figures there, that a record number last year. And I think this is testament to the work of the CM itself in terms of making itself more open to Rule 9 submissions and propagating to NGOs how to go about doing it, as well as to the work of the European Implementation Network, and we heard from George earlier. So some suggestions, I think, would be for the Committee of Ministers to have regular meetings with civil society representatives. There are, thanks to EIN, briefings organised in advance of DH meetings on particular cases, but this perhaps could become something even more well instituted. And also that states should be required, when they report to the CM through their action plans or action reports, to include in that the extent to which civil society has been consulted, or indeed proposals which have come from civil society. And then also the openness of the execution department to meeting not just government representatives on their country visits, but this wider pool of actors. Just very briefly to finish, we've mentioned yet again the importance of domestic structures. Here, the Czech Republic again gives a very good model under a conscientious government agent who has pulled together a standing group with representatives from the judiciary, parliament, academia, civil society, and so on. And I must mention also Parliament's this very underexploited resource in a sense in terms of implementation. Still across the Council of Europe, we see mostly weak, embryonic, or indeed non-existent structures. So the capacity building work that the Parliamentary Assembly does is crucial, and the political impetus that should also be given to this by this Committee of Ministers. Very finally, the importance of the execution department itself. Some research we did that was back in 2019 suggested that for every staff member of the execution department, there are about 155 cases. This figure may have changed, and I stand to be corrected by those on the meeting who are from the CM. But the importance of the execution department, Bashak's research has also pulled this out in her article, Foxes Guarding the Foxes, of the role of the execution department and the Secretariat as a kind of guardian of the norms of this process. So I think that attention should also be paid to having a suitably well-resourced execution department. Now I'll leave it there. Sorry to run over slightly, and thank you.
Thank you very much, Alice, for this excellent presentation. In 15 minutes, you have guided us through the complexities of this domestic, but also European ecosystem of implementation. But you also gave us a very clear suggestion to think forward, as the title of today's workshop says. Our third presentation focuses on a specific country, Turkey. It's the presentation by Kerem Altıparmak, who is one of the lawyers of the International Commission of Jurists, an NGO defending human rights and the rule of law worldwide. Premature closing of execution review, lesson learned from Turkey. Thank you very much, Kerem. Floor is yours.
Thank you. All right. Okay. Sorry. Oh. Okay. As you stated, I will be talking on a single country in a series of cases about impunity. As well known, Turkey ranks in the list of violations by article and by state, published by the European Court. And it also ranks second in violation of Article 2 and 3, both substantive and procedural limbs, after the Russian Federation. Until the end of 2020, there were 871 findings against Turkey. The court has found Turkey in violation of substantive limb of Article 2 for 141 times and procedural limb for 223 times. And Turkey has been found to be responsible for violation of prohibition of torture for 31 times and inhuman and degrading treatment for 253 times. The court also has found violation of article for lack of effective investigation for 200 23 times. As these figures show, impunity has been a systematic and structural problem in Turkey for at least 3 decades, for the last 3 decades. The question is, what happened after these 871 findings about impunity? Has anyone responsible for these violations prosecuted and or convicted for their crimes? There are different groups closed or pending before the Committee of Ministers. Aksoy versus Turkey was a huge group of cases. It was closed, but some of the complex problems included in this group transferred to other groups, Erdogan and others, Batı and others, and Kasa versus Turkey. A common feature of these groups is that the government does not take any serious steps in individual cases. However, as we will see, the lack of implementation of individual measures became a general measure problem in impunity cases brought against Turkey. In Erdogan and others, the Committee of Ministers, in its most recent meeting, noted with concern that no significant progress has been achieved with individual measures since the last examination of these cases. It appears from the authority submissions that in some cases, it is no longer possible to reopen criminal investigations because of statutory limitations. In others, the investigations or proceedings are pending without any significant progress. Exceptionally, in the Kasap and others case, a police officer was reconvicted of negligent homicide, but it's not clear from the information provided whether he has been sentenced or not. Similarly, in Batı and others group cases, the Committee of Ministers deeply regretted the lack of prompt reaction by the Turkish authorities, allowing cases to become time barred and thereby contributing to the atmosphere of impunity. Again, in this case, the Committee of Ministers enumerates a number of cases which were closed due to end of prescription periods. We can classify impunity cases according to their legal stage in 3 groups. When we're talking about those cases, these are cases about violations that took place in 1990s, but in some cases in early 2000s. Serious human rights violations that were committed in those years might be classified in 3 major groups. The first group is cases brought to the Constitutional Court after they became time barred. The second group, cases brought to the European Court of Human Rights before the prescription periods end. And the third group, brought to the Strasbourg Court on time, but time barred was the case was pending. So for the first group, which were brought to the Constitutional Court after they became time barred before domestic courts, in the first judgment, the Constitutional Court, Gülenay judgment, concluded that domestic authorities had failed to provide effective remedy as the case had become time barred. However, in that case, the court did not order the reopening of the case, as it was de jure impossible under domestic law to reopen a criminal investigation. However, later, starting with Adile Azizoğlu and following judgments, the Constitutional Court departed from this jurisprudence. And in all relevant cases, it has held that the applicants had failed to show due diligence in challenging authorities' failure to investigate serious human rights violations before the Constitutional Court when the individual application system had been introduced in Turkish law. in all those cases, incidents took place in 1990s when individual complaint mechanism did not exist. However, the Constitutional Court concluded that applicants should have known in September 2012 that they had to lodge their applications before the court, if at that time it became clear that there was no effective investigation according to convention standards. This is odd, as even the Constitutional Court itself was not aware of this duty whilst deciding in the Gülenay case in 2016. However, practically this new jurisprudence ended the possibility to discuss state responsibility for gross human rights violations that took place in 1990s. Once reaching this conclusion, the Constitutional Court relied on the Strasbourg jurisprudence. The European Court itself ruled that where an applicant first pursues a domestic remedy and only at a later stage becomes aware or should have become aware of the circumstances which make that remedy ineffective, the 6-month period might be calculated from the time when the applicant becomes aware or should have become aware of these circumstances. Following this jurisprudence, the Constitutional Court held that the applicants should have become aware of the ineffectiveness of the remedy at the time when the individual application mechanism was introduced in Turkish law. The second group is cases brought to the European Court before the prescription period's end. Unlike the first category, some serious human rights violations brought to the attention of the Strasbourg Court before the end of the prescription period on the ground that there was no effective remedy available at the time. In those cases, the Strasbourg Court has concluded that applicants' claims had not been duly investigated by domestic authorities. However, these cases also ended with impunity. In Yurtsever and others, the European Court found the government responsible for the death of applicants' relative, both under substantive and procedural limbs of Article 2. Following the judgment of the European Court of Human Rights, a fresh investigation was launched. However, no police officers were convicted, as the Court of Cassation concluded that all defendants should have benefited from doubt. The Constitutional Court did not find a violation in this finding. In Kaymal's judgment, the European Court once again found that both substantive and procedural limbs of the right to life had been violated. Yet the applicant's request for reopening of the investigation was rejected on the ground that it did not fall within scope of Article 317 of the Code on Criminal Procedure, which provides a rule about the reopening of cases following the judgment of the European Court of Human Rights. According to this rule, a person who wins her case in Strasbourg can request the opening of the criminal procedure under which she had been convicted. However, if the European Court concludes in application that Article 2 of the Convention has been violated due to acquittal of perpetrators, the applicant cannot request the reopening of the criminal case relying on a Strasbourg decision. In other words, reopening of criminal procedure is available only for those who were convicted in violation of the Convention. However, a request for reopening a criminal case against potential perpetrators cannot be initiated, as the rule does not give a right to the victims of crimes. In the only positive example where the Constitutional Court found that non-implementation of the Strasbourg decision violates the Constitution, perpetrators were not brought to the justice either. In Benzer and others versus Turkey, the European Court concluded that 34 people were killed by an air bombardment conducted by the Turkish military. However, the investigation was time-barred despite all efforts of the applicant's lawyer. In Abdulaziz Bengi and others, the Constitutional Court held that non-implementation of the judgment breached the Constitution, but it did not order a start new investigation is time barred in the case. The last big group is cases brought to the Strasbourg on time, but time barred once the case was pending. In some other cases, victims lodged their applications to the Strasbourg court, but the prescription period ended whilst the cases were pending before the court. So the question was whether the court should have examined the case in details, or it could accept a unilateral declaration of the government. In Karaca versus Turkey, the court noted that a de jure impossibility to reopen proceedings in cases concerning complaints under Article 2 and 3 of the Convention is not in principle an impediment for the Committee of Ministers to close its examinations under Article 46 of the Convention. For example, the court says, following the Grand Chamber's finding of a violation of Article 3 of the Convention in its procedural aspect, in the case of Yaronovitz, the applicant requested the national prosecutor to reopen the investigation into his allegations. His request was rejected on account of the expiry of the limitation period. In its resolution, the Committee of Ministers considered that all the measures required by the convention had been adopted. Again, in Tashdemir versus Turkey, the court stated that there may be situations where it is de jure or de facto impossible to reopen criminal investigations into the incidents giving rise to the applications being examined by the court. Such situation may arise, according to the court, for example, in cases in which the alleged perpetrators were acquitted and cannot be put on trial for the same offense, or in cases which the criminal proceedings became time barred on account of the statute of limitations set out in national legislation. In that case as well, the court accepted the government's unilateral declaration and did not continue to examine the case. So as a result, after hundreds of cases and at least 871 violation findings, the period of serious human rights violations in Turkey has ended with full impunity. Neither those who waited until the end of prescription period to lodge an application before the Constitutional Court, nor those who applied to the European Court at an earlier date could bring perpetrators of gross and serious human rights violations to justice. Perpetrators of the most serious human rights violators at last and are lost in a procedural maze created by this international law mechanisms. So I think it is worth to ask a question then: how an effective implementation mechanism in impunity cases can be developed, considering the abuse of prescription periods to continue the impunity regime? Thank you.
Thank you very much, Kerem, for your extremely precise and informative presentation, which raises serious questions about the effectiveness of implementation of these judgments.
Thank you very much again to Professor David Paris from the University of Foggia and also from the Max Planck Institute, and also to our fantastic panelists as well. Thank you. Recording. Okay, well, good afternoon, everyone, and welcome back to our workshop on the execution of the judgments of the European Court of Human Rights. This is our afternoon session. For those of you who may just have joined us, my name is Başak Çalı, and I'm one of the co-organizers of the workshop from the Center for Fundamental Rights at the Hertie School. So before I give the floor to my chair for our third channel on resistance to execution, let me just remind you of the technicalities of I'm sure yet another Zoom session that you may have taken part in the past year or so. So we are recording the event as we did in the morning, the sessions. and the recording has just started. We have presentations. In the first part, of course, there's going to be an opportunity to make comments and ask questions after this. And we have, we suggest that you can pose your questions in the Q&A function of the Zoom by typing your question there. Or you can also raise your hand, and then our chair, Niels, would call on you when you raise your hand, and you can actually take the floor and also pose your question in that way, which all of this have worked very well in the morning session, so I have no doubt that we'll manage in the afternoon sessions as well. So without further ado, let me give the floor to the chair of the third session, Niels Muijnieks. He is currently Regional Director for Europe, Amnesty International, and he was a former Commissioner of Human Rights of the Council of Europe prior to that. Thank you very much, Niels, for chairing this session.
Well, welcome everybody to the panel on resistance to execution, and thank you so much to the organizers for having me. It's a great event and a great panel. Delays and deficiencies in execution are often relatively easily explained away. Governments can say, we don't have the resources. We cannot reach a political agreement within our country. We lack expertise to do this well. The issue is very complex and will take a long time to resolve. We need more time. But resistance to execution is a different kind of challenge, I think. And in this panel, we're going to look at some of the toughest nuts to crack. Resistance from a backsliding state such as Poland, resistance to execution of Article 18 judgments, which were rare until recently and typically involve very high-profile opposition figures. I remember when Azerbaijan started locking up all of its human rights defenders during its presidency in 2014, there were a lot of discussions at the top levels of the Council of Europe, and the Article 18 cases started coming in. And that was the first time I heard that Article 18 violations should set alarm bells ringing. And then as commissioner, when I continued my work over the next couple of years, I urged activists in Russia and Turkey to invoke Article 18, and many of them did so, and I also intervened as a third party in a number of those cases. So I'm very interested in the lessons that can be learned there. I feel partially responsible for the surge in Article 18 cases because I wanted to ring many alarm bells in the Council of Europe. Finally, we'll also be discussing resistance leading to infringement proceedings. We saw it in the case of Ilgar Mammadov against Azerbaijan, and Amnesty International recently called for infringement proceedings to be initiated against Turkey in the Kavala and Demirtas cases. And we will continue pushing, and we hope to help stiffen some backbones in the Committee of Ministers and elsewhere. To discuss these tough nuts, we have a great panel. First of all, we have Adam Bodnar, who as Poland's ombudsman has valiantly fought against human rights backsliding in a very difficult context. In a recent ruling, the captured Constitutional Tribunal recently paved the way for Adam's departure from his current position and replacement with a government stooge. He is also affiliated with the SWPS University of Social Sciences and Humanities in Warsaw. Welcome, Adam. Next we have Bashak. Yes, sorry. Next we have Professor Bashak Chali, one of the organizers of the conference, Professor of International Law and co-director of the Center for Fundamental Rights at the Hertie School. And finally, Konstantin Jeciaru, Professor in Human Rights Law at the University of Liverpool. Adam, the floor is yours. Take it away.
Thank you, Niels, for introducing me. I would like to start by thanking Middlesex University and Professor Philip Leach and Alice Donald and Professor Alice Donald for invitation, and of course Bashak Chali from the Hertie School of Governance also for inviting me. And I would like to share with you some of my thoughts concerning some of the problems that we are having with the
implementation of judgments of the European Court of Human Rights, taking into account some of the developments, both in my country, but also, I would say, in a legal discourse. So I thought that it might be interesting to look at what is happening with the implementation of judgments from the point of view of a concept of so-called principled resistance. So there was a very important book published a couple of years ago by Professor Martin Breuer that was published in so-called Schwarze Reihe by Max Planck Institute on the concept of principled resistance. And in this book, taking into account some of the problems we are facing over previous years with the implementation of some judgments concerning such countries like the United Kingdom, Italy, or Russia, the idea has emerged to discuss it that maybe there are some reasons that some countries have some principles behind resisting to implement some judgments. So the argumentation was that maybe there are different reasons for courts, domestic courts, to enter into a dialogue with the European Court of Human Rights and to resist implementation of judgments. And I think each of the participants of this conference, for example, remembers this long time dialogue with the United Kingdom concerning the implementation of the case on prisoners' voting rights. I think that was the most important case of this regard. And I think, and also I think the UK example shows it, that this idea of principled resistance was a little bit a result of pressure coming from inside countries, from domestic electorate, from politicians that were very much afraid that a European Court of Human Rights is trying to do too much and to put too much emphasis on how rights should be interpreted and should be then applied. And I think that this whole discussion on the principled resistance is to a great extent based on good faith. By good faith, I mean the fact that those countries in which we have this discussion and those courts, they try to find a way to accommodate human rights models within their countries with supranational model of adjudication. And I think there is a very interesting, very good quotation from Ed Bates, from Professor Ed Bates from this book. I quote, "Strasbourg may have the final word as authoritative interpreter of the convention. However, its right to decide needs to be seen in the context of its relations and dialogue with national institutions, including the United Kingdom Supreme Court, which has found new confidence and assertiveness in relations with Strasbourg." The end of quotation. But the question is, in my opinion, do we accept this trend of basically agreeing on that kind of a principled resistance approach, or whether rather we should stick to the fact that international treaties should be just observed, and we shouldn't find some ways to escape responsibility of states to protect rights as they are guaranteed under the convention, and to escape obligations under Article 46 of the convention. But there is like new element of this discourse is the ratification of protocol number 15 to the convention and the entry into force, because it seems that protocol number 15 is basically a result of pressure coming previously from different intergovernmental declarations in Copenhagen, in Brussels, in Oslo, when this issue of subsidiarity has been underlined in all different contexts, subsidiarity and margin of appreciation. And I think it is important to underline that subsidiarity as such applies not only at the stage of, let's say, use of domestic remedies, but there is a general concept that subsidiarity also applies to the stage of enforcement of judgments. And for example, the choice of general remedies is to a great extent part of the subsidiarity principles, that it is up to the state to find out which remedies are proper in a given circumstances, in given cases. But the problem is that it seems to me that if we can connect this principled resistance with the subsidiarity principle, and then it may end up that countries simply would say that, okay, we are referring to subsidiarity, which means that some of the judgments will simply not follow, will simply not not enforced. So the question is it not something like a slippery slope type of a situation that on the one hand, there is a pressure coming from domestic courts of not to enforce some judgment. There is a pressure coming from national authorities to seek for some kind of argumentation, which sounds quite nicely that because of principles we cannot implement those judgments. And on the other hand, we have in the very system of the convention, the principle of subsidiarity, which is becoming stronger and stronger because it is becoming the part of the very direct language of the convention, and it gives a chance for the ECHR system not to be so effective as it was. And I think that certainly, you know, I appreciate and I think this discussion at this level of, let's say, old members of the system of the European Convention on Human Rights is very much important. And as it was said, I think it contributes to the discussion on the content of this, on how this whole machine of the ECHR control mechanism should work. But let us think about it, that if we use that kind of practices and that kind of an argumentation, then we should not forget that there are countries that may abuse that kind of concepts in order to achieve their own political purposes, in order to discredit the system of the convention, or in order just not to do anything in order to implement judgments or to prolong the discussion on the implementation of judgments. So we remember this famous discussion on Konstantin Markin against Russia case, where there was this principled position of the Russian Constitutional Court not to implement some judgments. We may see, and we have discussed some of those examples during previous sessions, examples coming from Ukraine, Azerbaijan, Turkey, other questions. So the question is, in my opinion, to what extent and how that kind of concepts, which are very general and quite sophisticated in nature, like this concept of principal resistance, in fact, translates into the practices of some countries that are not simply complying with human rights standards, and basically that seek for different reasons not to comply with those human rights standards. So we may ask a question, and one of the authors in this book is asking this question, okay, so what is the choice? Shall we seek for some way to accommodate those countries, not complying countries, into the system with the use of that kind of new paradigms, or maybe we should rather push towards leaving, towards those countries leaving the system of the convention. And you know, I will be the last one to say that those countries should leave the system of the convention, because I believe highly in the individual justice that is provided to individual human rights victims of human rights victims. But we should be aware that any discussion that is taking place in this international discourse is later on having the impact on abuse of that kind of concepts at the domestic level. Looking at the Polish examples, you know, we have some cases that are not enforced for years. So it is one of these problems. So I think the most important cases of this nature are cases concerning access to legal abortion. So please note, they are not only not properly enforced, but right now even we are in a situation when the Constitutional Court in Poland, this captured Constitutional Court, has even limited access to abortion even more. And when we have that kind of a concept of principal resistance, I can just easily imagine Polish government saying, oh, you know, it is our constitutional principle. We are not going to obey with any pronouncements this time, or even with some future pronouncements of the European Court of Human Rights. Or another case, and Niels was heavily involved into this case, the CIA rendition case, which, you know, 6 years have passed from the moment of the delivery of the judgment, and the last decision of the prosecutor's office was to redeem proceedings in the case. So now, right now, this decision of the prosecutor is appealed to the regional court in Warsaw. But it is one more example that in this very high level, serious cases, governments tend not to do anything with those cases. Certainly, this discussion, when it comes to Poland at least, could be interesting from the point of view of the relevance of the general principles of the convention system to the Polish situation, but we should know, and I think everybody is aware here, that Poland is suffering heavily due to the rule of law crisis. And sometimes, even when I personally deal with the enforcement of the ECHR judgments, both as in my role as the ombudsman and in my scholar capacity, so I have sometimes a feeling that it is a little bit like, protecting roses when the forest is burning. That you are taking care about some really detailed issues when you have much bigger problems. But those bigger problems obviously have a huge impact also on the system of the convention. And especially in the Polish context, it is interesting because Poland was, before 2016-15, one of the most loyal members of the system of the convention with I remember, for example, a joint endeavor made together with the Middlesex University when in the Senate of the Republic, I have organized a conference on the role of parliaments in the implementation of judgments. So something that is almost impossible to even think about it in Poland these days. But interestingly, we see, despite the crisis, we see some positive elements like the involvement of NGOs, Bar Association, also my institution in the enforcement procedure, submission of Rule 9 communications. Also, I know that Polish NGOs support heavily European implementation network. And I see also that there is a lot of use of Strasbourg jurisprudence in the daily practice of Polish courts. But at the level of top institutions, at the level of parliament, at the level of the National Council of Judiciary, top courts, this use of the Strasbourg standards and the implementation of judgments is at much more lower level than it was before. Moreover, we see a pressure towards superficial closure of monitoring procedure by the Committee of Ministers. And I think the police brutality case is a good example of this, that the case is closed, but in fact, right now, these days, we have even more police brutality than ever before. And in this context, I think we should underline two elements, that when we have that kind of a machinery, that kind of a supranational system, when there is a crisis of the rule of law, then governments tend to undermine the system. For example, by saying that maybe some of the issues are not directly framed into the convention. Martin Kuyer was writing about this, that sometimes countries are seeking for rationale why not to comply with, for example, by saying that some of the elements, some of the interventions by ECHR are going beyond the convention system. And for example, I couldn't imagine a couple of years ago that Poland would be a country refusing to implement interim measure, and such things happen. And when you look from the point of view of the system of the convention, you may hear an argument. Maybe this argument is not expressed directly, but some other countries may use it because this is just the competence of the court on the basis of the rules of the court and not on the basis directly of the convention provision. And the second problem is that the political subordination of highest courts may lead towards hijacking the system because, how can you make a political dialogue with courts if those courts are captured or politically oriented, when there is no trust in this dialogue between highest courts and the ECHR. And finally, there is a process of attempt, at least, to influence the court from inside. And I should mention here that recently the list of Polish judges candidates to the ECHR has been rejected by the General Assembly, by the Parliamentary Assembly of the Council of Europe. My last point is delay. We can talk all different things about system of implementation. I have mentioned this case of access to abortion, and this implementation already lasts for, 13, 14 years at least. And even the situation is much more worrisome than it was before. But please look, just one specific example. We have one of the sources of the crisis of the rule of law in Poland is the situation in the Constitutional Court. And the European Court of Human Rights will issue a judgment finally on this on 7th May this year, so next week. But this situation happened 4 years ago, 5 years ago, the very source of the problem. Or, for example, there are cases concerning access to registered partnership by LGBT persons. So, I remember that I have submitted my case on this when I was working for the Helsinki Foundation, I think in 2013, and it was communicated, I underline, communicated to the government of Poland in 2020. So please add to this then additional year or 2 or 3 for the judgment, and then please add to this additional years for implementation. So it is a huge problem that sometimes we are thinking about all different kinds of new procedures and new methods of putting a pressure when the system is simply not effective from the point of view of simply time. So what is my conclusion? My conclusion is that, first of all, when we invent or when we try to shape this relationship between top courts or national authorities and the convention, and we try to use that kind of new phrases like principled resistance, we should be aware that that kind of concept will be used in abusive fashion by those member states that are not going to comply with the convention. Second, we should take a special attention towards the length of proceedings before the ECHR, towards the transparency of proceedings and predictability, also involvement of the civil society actors. And in order to do it, I think we should also put a pressure on on those countries that are supporting the system to make a really huge injection of resources into making the system as much effective as possible. And in this respect, I'm quite happy to see that there is a lot of discussion about the involvement of the European Union into the system. And maybe from this perspective, not only accession, but in general support by the European Union could be a good instrument to strengthen the efficiency of the whole system, also at the level of, or maybe additionally at the level of enforcement of judgments. Thank you very much. Thank you for your attention.
Thank you. I have a number of questions, but I will hold on to them until later. Why don't we first go through the basic presentations and then have a discussion and questions. Bashak, you're up next. Bashak will discuss lessons learned from the execution of Article 18 judgments. Please, the floor is yours.
Thank you. Thank you very much, Niels. I'm going to see if I can share my screen with you, and if I can get you a nice view. I think, is that okay? Are you able to see this one? Yeah. So in this sort of 15 minutes, I want to reflect on whether we have learned any lessons from the execution of Article 18 judgments. I think maybe we have, but this is an open-ended question for a number of reasons. First, as you know, there's only 18 Article 18 judgments so far. So this is not a very large number of universe of cases. And Article 18 judgments have been delivered in relation to a small handful of countries, including Moldova, Russia, Ukraine, Georgia, Azerbaijan, and Turkey. So it's a very small kind of sample. So you can say, you know, what can we learn? What kind of lessons we can learn from that? Thirdly, we should say that as we have discussed since this morning, execution of judgments is a very long process. And a lot of the cases that I will be referring to are still under ongoing supervision. So these are not closed cases. So you could say that, you know, these are unfolding processes. You know, how can we learn lessons? So I want to sort of reflect on lessons, but just put those things, the 3 points that I've just raised into, you know, I think this will help us to put those, what I call lessons, into some kind of perspective. So I've been studying the execution process of Article 18 judgments for the past year or so now, and been writing about this. And of course, one of the first questions that we ask to ourselves, even though now there's a big hype about Article 18 judgments and we're all talking about them, but it's worth asking what is so unique about them. Given that we have a lot of other judgments, which are also very important, they're not implemented and they may be resisted. And Adam has just raised some cases from Poland. and these were not Article 18 judgments, for example. So one of the reasons why we pay maybe a little bit more attention to these judgments is their sort of declaratory significance. So these judgments tell us that an individual's rights are not just violated, but that they were violated in bad faith. This is an Article 5 in conjunction with 18 or 11 in conjunction with 18 or what have you. It just tells us a much more of an aggravated story about the facts that lead to a violation. So the bad faith violations are understood to be in a declaratory way a lot more of a serious type of a finding than arbitrary deprivations, which, as you know, is a very common way of violating the convention through arbitrariness. But of course, this has also been connected more and more so, and only perhaps more recently, I would say, to the convention and the travaux of the convention, and a rereading of the convention's travaux, especially Henry Teitgen's contributions, the French statesman's contributions, that the convention is an alarm bell. But in particular, we have been having some discussions and scholarship that Article 18 is an alarm bell. So, this also has this symbolic significance, not just about the individual, but more generally. So those are some of the things that we seem to sort of assign these values to Article 18 judgments collectively. But of course, on the sort of the picture of individual and general measures, it's very much related to the declaratory point that Article 18 judgments really require very demanding, if I may say so, reinstitution in integral measures. Because if a person's rights are violated in bad faith, they have to be really returned to that original position, and there shouldn't be any sort of qualms about that sort of reinstitution of that person to that original position. But of course, what we have seen in the court's case law, when the court says that the rights are violated in bad faith, in particular in the judgments since 2014, the court has also been very much underlining, what it means by bad faith, and it actually says the bad faith had to do with political bodies influencing the judiciaries, or judicial bodies acting under influence of political organs. So when you unpack it like that the bad faith comes through an influence, a political influence over judiciaries, obviously these judgments require some very important structural reforms to ensure the impartiality and independence of judiciary, in particular from political influence. So they seem to be pretty significant, and maybe that's why they're very rare, compared to last year there were like thousands of judgments and just one or two handful of the Article 18s, and so on. So these are the kind of the cases that we currently have. And so this is kind of the picture that we have. So I just want to say a couple of things about these cases, and I'm not going to obviously go into detail about each and every of them, but this is just to give you a sense of where we are with the Article 18s. Now, one of the things we see is that the earlier cases, the Moldovan case and the Buzinski case, even by the Committee of Ministers, weren't really treated as what I've just described as Article 18 cases, attracting some significance. They were actually standard cases. They were not, discussed at length about the Article 18 aspects. And actually, the way that we started understanding Article 18 cases is engaging sort of harassment of politicians, human rights defenders, and so on, I think has really started with the Mammadov judgment much later on. And I know that we will later on discuss infringement proceedings as well. So one of the things that stand out in this table is the Ukrainian Article 18 cases, where we have seen some exceptionally far-reaching measures taken by the Ukrainian authorities to specifically respond to the Article 18 aspects of the case. So both in the case of Lutsenko and Tymoshenko, you know that in the case of Lutsenko, there was a presidential pardon. In the case of Tymoshenko, I think the parliament has actually reinstituted the rights, as well as the Supreme Court, and there were sort of criminal proceedings to reinstitute the rights of both applicants And Ukraine has also made this very unusual commitment that it will look at all other cases. It will create a domestic procedure for all other cases that might have an Article 18 aspect to it. But if you leave the earlier cases where no one was treating them as Article 18 cases, as I've described, and Ukrainian cases, most of the other cases that we currently have are not closed. They're ongoing in terms of their supervision. And in a lot of these, you can say it's very understandable that general measures are ongoing. We know that general measures always take a lot of time. But what is very significant about all of these cases are that the individual measures are pretty much ongoing. So which means that the full restoration of the rights of applicants whose rights were restricted predominantly because of political measures, political motives that were not deemed as legitimate by the court, have actually not been fully restored. And you see that the attention to these cases have significantly increased. They're all enhanced procedures cases. And of course, Kavala versus Turkey stands out here because it went beyond almost, I would say, enhanced procedure, because now it has to be examined at every regular and every human rights meeting of the Committee of Ministers, precisely because the individual measures of the release of the applicant and not just the release, but the full institution of the rights, so that the criminal process that criminalizes these individuals is cleared up. These are not respected. So there are some fundamental issues and problems. In some of the cases, of course, very high profile, also other cases like Navalny, we also know that the Russian Federation hasn't submitted any action plans in those cases. So the supervision is not even in some sort of an ongoing process, even before the Committee of Ministers. The Azeri cases are, they're also subject to individual measures, and the individual measures in these cases have been somewhat successful or partially successful in relation to some of those in the group, a Mamadli group, but it is also been pointed that these are taking a lot of time to actually even secure those measures. So this is just a very rough overview, and some of you may be a lot more intimately familiar with those cases and what's going on before the Committee of Ministers with our very small universe of Article 18 cases. And I must highlight that, these are all ongoing cases. So what do we see from this experience from 2004 until 2020? So this is kind of a 15 years space, but I would say really from 2014, because the earlier Article 18 judgments were just, everyone was like, oh, that's interesting, but nobody was sort of really assigning the significance we have come to assign to Article 18 very recently. So I see, a couple of issues here. One of them is looking at, in particular, the ongoing and pending cases before the Committee of Ministers, minus Ukraine, right, minus Lutsenko and Tymoshenko. We see that these cases may lend themselves to what we may call the incentive to politicize the execution of judgments more likely than other judgments, because the court is really pointing a finger at the domestic authorities for having ulterior, illegitimate political motives. So unless you agree with the court that you do have ulterior, illegitimate political motives, you would say that you do not have ulterior, illegitimate political motives, and you would exactly say you have the opposite. And the only example we have here is Ukraine, where the regime itself, because the domestic structure in Ukraine has changed, and the politicians were rehabilitated and re-accepted into the political regime in Ukraine, that we have seen the execution of those cases. But of course, in other jurisdictions, in Turkey and Russia in particular, we don't have this kind of a regime change. So Article 18 judgments are really pointing the finger at authorities for having illegitimate ulterior political purposes. And I think it gives them, unfortunately, an incentive to then say, no, how dare you, you say that. So this is a problem for execution. That's what I want to highlight. It makes it harder to execute these judgments. The second thing from the pending cases that we see here, and again, Ukraine is as an outstanding example because it actually had a domestic procedure to say, your right, we are recognizing that your rights were violated in bad faith. So they have introduced a procedure. But in all other cases, what we're seeing is that the national courts are not good compliance partners for the Committee of Ministers. Why? Well, the judgments say so, right? The political bodies are influencing the judiciary. So this makes it very less likely for the national courts to be compliance partners. So we have this very protracted criminal trials of Mr. Kavala, for example, ongoing before Turkish courts. The Constitutional Court of Turkey is also involved in all of this. And they're not really supporting anything of the swift execution. So the judgments sound very noble, but they, I think, create even bigger execution problems because of exactly what they say. So what do we do? And maybe one last point in that is that, of course, the Council of Europe has understood these judgments, in particular since Mammadov, and they are demanding full reinstitution in integrum measures, and they've been sort of closely monitoring them. But of course, another issue is that there's a big disconnect between the Council of Europe's English and French sort of documents and the discussion about these judgments in the domestic contexts. So you have, these, as Alice called them, an ecosystem. I think you don't have an ecosystem in Article 18 judgments, a very sort of a contesting kind of environment there. So what can be done? I mean, one of the things, I think one of the lessons learned is that precisely because of what the Article 18 judgments say, it is really hard to execute them if there are no regime changes or independent judiciaries. And of course, the judgments say judiciaries are not independent, then you're caught up in this vicious cycle in relation to execution. So for everyone else around us, I think one point that I gather is that, of course, what needs to be done is, and also a practice that the Committee of Ministers has started, but I think it has to really improve and be consistent across all the Article 18 cases, is to continuously call and continuously and very demandingly monitor urgent, comprehensive individual measures and general measures. And of course, this requires huge amount of time, maybe looking at Article 18 cases at every meeting, not just for Kavala, but in principle for all Article 18 cases. So if they're scarce, if we have 18 of them, maybe they do demand exactly more time because they're harder to implement because of exactly what they say. So what we've also seen is that the earlier cases didn't attract any Rule 9.2 submissions, very limited submissions of any kind. And now there's huge amounts of interest from the civil society in Georgia, for example, also from the NHRIs, from lawyers, from the High Commissioner, and so on. But these cases require a huge amount of investment also by legal representatives, NGOs, and the High Commissioner, because delivering, if you will, an Article 18 judgment, if there's no political regime change, makes them incredibly difficult to execute. Thank you. I'll end there. Yes.
Next, I want to give the floor to Konstantin Zetziaru, who will talk about infringement proceedings. Can they make a difference? Konstantin, the floor is yours.
Thank you very much. Thank you very much, Niels. And thank you very much, Başak and Adam, for setting the standard so high that it will be very difficult for me to catch up with that. But in the beginning, I wanted to sort of reference to what Adam has said, because I also participated somehow in developing the idea of principal resistance, and I wanted to defend it a little bit. The fact, I still think that principal resistance can happen to the judgment of the European Court of Human Rights. The fact that this idea can be abused does not mean that it is not happening. This is one of the issues that I wanted to point out. The second issue is that even principled resistance is not a good justification for non-execution of judgment. That is an important issue that often is missing from the discussion. So even if the state has and can have like principal resistance and principal dissatisfaction with the court judgment, and the court is the human institution which can make mistakes every now and then. It is not a holy cow. So therefore, the resistance is possible, but the outcome of this resistance is not that the judgment should not be implemented. As we know, all judgments of the European Court of Human Rights should be executed according to Article 46 of the European Convention on Human Rights. Other decisions of the court should also be executed by virtue of Article 32 of the convention, which states that the court is a master of interpretation of the convention. But what should happen if the judgments or decisions are not enforced by the state? The system of the implementation of judgments, and that has been said on many different occasions, is relatively weak. The court cannot forcibly impose the execution of its judgment on the respondent states. Of course, the court doesn't have bailiffs, doesn't have police to make sure that the state is in compliance. It cannot put fines effectively on the respondent states to force execution. Moreover, a different body of the Council of Europe, as we all know, is responsible for the implementation of the court's judgment. It is the Committee of Ministers, which acts through persuasive powers, reputational threats, rather than direct enforcement through, for example, military or economic coercion. The nuclear option, the option of final resort, is suspension of the membership of the Council of Europe for the state that persists in non-execution of the court's judgment. Is available to the Committee of Ministers, but it has never been fully implemented, and currently it exists only as a theoretical threat. In this context, it's interesting what the court can actually do to improve its execution of its judgment. And the court's role in prescribing certain remedies and directing implementation was very limited. It is still quite limited, but recently the court became much more involved in the process of execution of its judgment. And just to remind you that at the start of its operation, the European Court of Human Rights could issue only declaratory judgment, meaning that the court would pronounce a violation of the convention, but it would not prescribe any measures that the contracting parties should undertake in order to ensure its compliance with the ECHR. In recent years, the court has become much more prescriptive about the measures a respondent state needs to undertake. Moreover, now the European Court of Human Rights can be involved directly in the execution of this judgment. In protocol number 14, the member states of the Council of Europe have given the court a competence to consider whether its judgment has been executed. This seems to suggest that the contracting parties do not object, at least, to the extended involvement of the court in the process of implementation, because they explicitly consented to the new procedure. But my question today is whether this process can make a substantive and sustainable difference. And my answer to this question is a qualified no. First, I would want to explain the mechanism of infringement proceedings quickly. The Committee of Ministers obtained the legal power after Protocol 14 came into force in 2010 to initiate proceedings before the court under Article 46, paragraph 4, which provides that the Committee of Ministers, if Committee of Ministers considers that a high contracting party refuses to abide by a final judgment in a case to which it's party, it may, after serving formal notice on that party and by decision adopted by a majority vote of 2/3 of the representative entitled to sit on the committee, refer to the courts the question whether the party has failed to fulfill its obligation under Article 46(1). Although the proceedings are designed to improve the implementation of the court judgments, the effectiveness of this mechanism is questionable, and this problem with effectiveness was introduced in the design of the procedure. And I would argue that although the court is provided with an opportunity to influence the execution, its real impact and effectiveness are problematic. Whether the infringement proceeding under Article 46(4) is likely to be useful, subject to a substantial debate. On the one hand, the Parliamentary Assembly of the Council of Europe, human rights activists, and some commentators encourage the Committee of Ministers to use infringement proceedings against the states on which other forms of pressure have been ineffective. On the other side of this debate are those who think that its utilization, the utilization of this procedure, will have a limited practical effect on improving the enforcement of court's judgments. The idea behind Article 46(4) was to give the Committee of Ministers an enforcement tool that would be more effective than mere diplomatic actions such as resolution and discussions with the state, but less detrimental to the Council of Europe than suspending a state's membership. However, the real questions here are the utility. First, it's not clear that the basic requirements for triggering Article 46(4) could be met in practice in relation to cases which are not exceptional. It is very difficult to achieve a two-thirds vote in the Committee of Ministers. The committee is a political body that is formed of the ministers of foreign affairs from the contracting parties, many of which have failed to fully execute some judgments against them. Picking out one country for Article 46(4) proceedings may lead to accusation of scapegoating and to nervousness among the other states likely to find themselves in the similar situation. That said, it is true that some states are more trenchant in their non-execution, especially in cases related to political dissents and the like, and might fairly be identified for infringement proceedings. And we can, as Bashak rightly said, in the case of Mamada, which I will be discussing in more detail in a couple of seconds, this threshold was reached. The second practical challenge is that by using the procedure, the Committee of Ministers would implicitly be accepting that it has failed in supervising the execution of a particular judgment. Even if the Committee of Ministers might do it on a very rare occasions, it definitely is not going to do it very often, that is for sure. Perhaps the greatest contestation of the question of infringement proceedings relates to what, if anything, they would achieve if the practical challenges of triggering Article 46 could be overcome, the ones that I have already discussed. And that was possible in the case of Mamada versus Azerbaijan. So the only example is Mamada versus Azerbaijan. In this case, the applicant was a political activist in Azerbaijan who was arrested for basically broadcasting or writing about some rally in Azerbaijan. Despite multiple requests from the Committee of Ministers to release the applicant, the Azerbaijani authorities failed to do that. The Committee of Ministers managed to indicate the infringement proceedings in this case, and one can argue that they were successful because the applicant was released even before the ECHR had a chance to pronounce its judgment. Moreover, it took Azerbaijani some time to fully implement the individual measures in this case. After 46 judgment was pronounced, and it was pronounced unanimously by the European Court of Human Rights, although the concurring opinion of some judges really sound like a clear dissent, but probably in order to enhance the legitimacy to the very first judgment under Article 46.4, it was voted unanimously. And from this isolated case, I think it's difficult to draw far-reaching conclusions about the effectiveness of this mechanism in general. Moreover, the nature of the right involved, the personality of the applicant, and the fact that Azerbaijan became among the clear outcasts in the Council of Europe created conditions for this infringement procedure to be effective. However, more general challenges related to the effectiveness of this procedure still persist. For example, it is not clear whether a finding of further infringement under Article 46.4 would really achieve anything from the practical perspective in other cases if they end up in the court. The reality is that an Article 46.4 procedure effectively tells us what we already know, that a state has failed to respect a judgment of the court. One might argue that if a state cared enough about its international reputation, that would have already executed the judgment in question in the first place, unless there is a genuine disagreement about execution of this judgment. But this is a very narrow issue, and then this issue can be dealt with by Article 46, paragraph 3. If not, it is difficult to tell, well, what difference a further judgment from the court would do to the willingness of to execute. Certainly, an adverse finding in an Article 46.4 proceedings may create greater and refreshed international pressure for execution of the original judgment. But the impact of this pressure cannot be easily foreseen. It would largely depend on the political reality that the court, on the political reality than the court's judgment. Much is likely to depend on how other political powers, neighbors, allies, and fellow Council of Europe members use this pressure created by the international court, and how domestic courts and domestic political structures also respond to it in a fresh litigation that might be taken at the domestic level. The potential usefulness of Article 46.4 may then lie in reigniting the effective political pressure on the respondent state to execute the original judgment against it, calling into question why effective pressure of this kind was not imposed on the state in the first place. But if the procedure is used in relation to more powerful states in comparison to Azerbaijan, like Russia or Turkey, they might completely ignore any political pressure. They would ignore the outcome of the infringement proceedings, as well as they ignore the original judgment, and that might have a very negative impact on the legitimacy of the whole system and the reputation of effectiveness of the Council of Europe system. Finally, the infringement proceedings do not necessarily need to preempt the suspension or expulsion of the member state, as it is sometimes argued. The statutes of the Council of Europe allows the Committee of Ministers to do that without any judgments of the European Court of Human Rights at all. The reality is that such judgment would add some legitimacy to the decision of the Committee of Ministers in relation to expulsion and suspension, but not much. I have already argued in one of my papers that the Committee of Ministers might be more willing than it is at the moment to make these steps in practice. So to briefly conclude, I think that infringement proceedings are unlikely to be very effective in relation to many cases, and it cannot sustainably improve the implementation of judgments of the European Court of Human Rights. Thank you very much for your kind attention.
So we have, in this 1 hour, we've invited an outstanding group of experts and scholars just to help us reflect on the day and also reflect on the broader issues. And all of them are also very familiar with these issues in the Council of Europe, also as well as from comparative perspectives. So each of our speakers is going to take the floor for 5, 6 or so minutes, and then we will also have a chance for final comments or questions or reflections also from the floor. And this roundtable is called Thinking Forward. So we will try to think forward collectively. So without further ado, let me just give the floor to Christos Chakomopoulos. He's Director General of Human Rights and Rule of Law of the Council of Europe for his way to think forward on execution. Welcome.
Thank you. Thank you. Thank you so much, Bashak, and thank you also for your participation in the previous panel, which I found extremely interesting with Niels, Adam, Konstantin, and you. I find it extremely challenging, and I think that we will have to come back in some of the aspects because most of the issues about the future challenges have already been raised, I think, in the previous panel. I have some difficulties to understand the notion of principled resistance, I must say. I think that it is clear from the Convention that the implementation of the judgment is a legal obligation, and I don't see any room for refusal, be it principle or other. And I don't think that we face actually, apart perhaps from the Greek case of the Greek colonials in the 70s, any formal refusal to execute a stated position that the judgment will not be respected. That would have been completely unreasonable in international law, because it would create not only a problem of human rights, but also a problem of international relations between states parties to the convention. It is a non-respect not only of the human rights, but also of the commitment towards the other parties to the convention to implement the judgment, because the commitment to implement the judgment is taken in front of the other contracting parties. But let me go to the issue. Where do we face major problems today, and how can we perhaps move forward? I think, first of all, there are some cases which traditionally, if I may say, present problems in the execution part. And I would say some of them have to do with the investigations into ill treatment or death caused by security forces or unlawful detention. In these cases, I would say one of the problems is that the facts, the time on which the judgment was given and the time of the execution is has a long distance, let's say, between the two. I think that the previous panel has also underlined this. It is usually what we ask for when we have ill treatment or death caused by security forces or armed forces is to reopen the investigation. If you reopen the investigation 10 years after the facts, which may happen, also because of the exhaustion of domestic remedies and the time the court takes to make its judgment, evidence may have disappeared, witnesses may have disappeared, and then you are in a situation where we have inefficient prosecution. The role of the convention in protecting not only the victim of the ill treatment, but also the accused, which is the policeman, and the presumption of innocence in the face of the inefficient investigation, create a climate of impunity. But I would be very much interested to hear what Clara will say about the transitional justice, because I think this is one of the aspects that need to be looked into from the execution perspective. Other aspects like the excessive length of proceedings, which are long-standing, I think someone asked this morning whether the Pinto remedy was really a good execution of judgment, or perhaps the poor conditions of detention. They are systemic in the sense that they require a coherent and a comprehensive effort from various sides of the state concerned, and also sometimes also money, funds, and this may take time. I think that one of the means that we have to look for the way forward in these cases is to increase the capacities of the national coordinator for the execution of judgments. I think that this is one of the most important parts. We tried in 2008 to put emphasis on the fact that the agent of the government, should also be the coordinator, or if it is not the agent, the coordinator should have sufficient seniority and means in the domestic legal order to be able to engage with the authorities and push for this. And I would say that another important aspect is the role of national human rights institutions, because they can also advise the government, make proposals so that the execution moves forward. I would say national human rights organizations, NGOs, are much more active than the national human rights institutions sometimes in this field, also before the Committee of Ministers, but also domestically. But I think this is changing, and we have increasingly national human rights institutions in all our member states that go in this direction. Now let me come to more complicated aspects. Interstate cases and individual applications that are linked to post-conflict situations. The progress in these cases, which are extremely political, of course, takes an enormous amount of time, and it requires a huge effort of consultation between the committee, the secretariat of the committee, and the states concerned. I would say that the execution process is even longer and even more difficult when the court findings relate to old situations, situations that go back to 10, sometimes 20 years, or when the procedure does not sufficiently actively the respondent party. I don't mean about the adversarial character. This is secured all the time. I mean a concrete engagement with the respondent party as to what are the execution means that are needed. Sometimes this is, since the decision on just satisfaction, for instance, comes not as a separate judgment as 30 years ago, but together with the merits. Sometimes we have the impression, at least, that it is not sufficiently considered by either the parties or before the proceedings or the court itself. I think that there we need an extraordinary efforts in the sense of intensive dialogue with the respondent states, and it is encouraging that the CDDH Steering Committee for Human Rights is now looking into how to deal with the resolution of cases relating to interstate disputes. This work has started in 2020, and I hope that it will progress rapidly. Many thanks to you also, Bacak, for the conference on the interstate applications that we had 2 weeks ago, or perhaps even less. I have lost the time with all these conferences that we are organizing now. Let me now come to Article 18 judgments, which I think is the third part of judgments that create problems. I want just to say that yes, a change of regime may of course contribute to Article 18 judgments implementation, but Article 18 judgments do not necessarily require a change of regime, and certainly they do not require a Maidan revolution, because then we are completely lost. I mean, I entirely agree with you. The change of the regime, has contributed to the resolution of the Tymoshenko and Lutsenko cases in Article 18, but in particular on the individual measures, by the way. But we don't need to go through a revolution each time we have an Article 18. But it is clear that Article 18 cases require an enormous effort, because, as you and several of you have said before, they signal that there has been a bad faith on behalf of the authorities in one, and it is very difficult for the authorities to accept that they have behaved in bad faith. So this part, reopening with acquittal against the decision that has reached to the final level of the instances, judicial instances in a member state, is extremely complicated. But I would say that Article 18 cases have also another very positive effect, in particular the fact that they may act as a reversal of the burden of proof. You know that in many cases we have Article 18 cases linked with pre-trial detention, and the fact that we have a finding on Article 18 makes the court, but also the Committee of Ministers, enables, I would even say, the Committee of Ministers to look into the post-pre-trial detention, into the conviction from the perspective of the findings of the court in the pre-trial detention case. So the presumption that someone who has been convicted is to a sentence, is detained because of this sentence, and so that this imprisonment is justified under 5.1a of the convention, may no longer be sufficient if you have his previous detention under 5.1c, the pretrial detention, quashed by the court in Strasbourg, together with an Article 18 violation. And I think that this is an important aspect of Article 18. Do we need general measures under Article 18? It's a very big question, I must say. I'm certainly some, but I wouldn't go as far as you insinuated that, Bashak, before, to say that we need to go into a general reshaping of the whole issue. I think that we feel that there are problems with independence and impartiality of justice in some Article 18 cases. We would not go as far as saying that the whole system is completely not independent and not impartial. How to go about it? Yes, we had some successful outcome in the case of Mamadov. If need be, I can also come back to the article of problems of 46.4 that Konstantin said before. But I think that what is more important in these cases is that prevention of similar violations beyond the individual measures, so require efforts not only from the state concerned, but also from the other member states of the Council of Europe, the Committee of Ministers, diplomatic interventions, intensive interaction with all, Committee of Ministers presidencies, for instance. So I think that these are the avenues that we at least would try to explore, not in the very distant future, but in the coming months and years, I would say, in respect of this. Thank you very much.
Thank you very much, Christos. This was also very nice that you divided up challenges under different types of cases, rather than sort of looking at it as just a big problem, maybe in and of itself. So let me talk, let me now turn to Isabel. Neatly Sprache. I gave it a very German touch, Isabel. Probably that didn't come out very right in your last name, but Isabel is a government agent in respect of Belgium and also has been working on the execution of the judgments of the Committee of Ministers for some time. Very delighted to give you the floor. Thank you.
Thank you, Bashak. Dear colleagues, like you, I'm convinced of the utmost importance of the execution of the court's judgments. As the Brussels conference recalled in 2015, it is a shared responsibility between the court, the member states, and the Committee of Ministers to make the convention a living, useful, and respected instrument. This is the reason why I would like to say a few words about the execution of decision of the court following unilateral declarations, the reopening of the proceedings after a long delay, before concluding with the difficult to find balance between limited and extended execution, meaning the dilemma sometimes faced when having to decide whether aiming for a final resolution to be adopted within a reasonable time or waiting until a long reform is fully completed. In Belgium, the reopening of the proceedings is possible not only after a judgment, but also after a friendly settlement or a unilateral declaration. Like in many countries, friendly settlements and unilateral declarations are slowly getting accepted by the authorities when the change to avoid the court finding a violation is thin. An important aspect of the work of the agents is to make clear to the authorities it can be worth it not to initiate or prolong the debates when the court's case law is clear, although the case could have its particularities. In the case Willems and Gorgon against Belgium, related to allegations of excessive formalism, there was one and only misunderstanding with the Belgian Court of Cassation. Instead of consulting me to see how it could be possible to get a step behind and immediately withdraw the unilateral declaration she didn't agree with, the Court of Cassation rejected this declaration and the court's decision following it in the examination of the reopening request of the applicant. This is fortunately an unusual example of misunderstanding with the agent and the refusal of the authority of the court's decision, but it is still one. My conclusion in this regard would be that without constant dialogue between the agents and the department responsible for the future execution of the court's judgment, we still can face major executions problem, even if, like in Belgium, there is a formal and in general well-functioning opening of the proceedings. Another major challenge to the execution of a judgment might be time. When the court concludes to the inefficiency of a criminal investigation and says it affected a victim's right, reopening the criminal case might be the best possible way to execute the judgment and redress the violation. However, the proceedings before the court being long, reopening will most likely be met with legal and practical issues. The most obvious would be prescription, but there are also practical difficulties, for example, with the collection of evidence of testimonies. A new process could be very difficult to organize under these circumstances. Applications and judgments linked to the inefficiency of a criminal investigation should therefore have the priority. But in practice, the workload of the court and the national authorities often prevents a swift handling of these cases. This leads me naturally to the conclusion of the difficult to find balance between limited and extended execution. On the one hand, there is undeniable advantages of having a final resolution adopted within reasonable time without having to wait until a reform is fully completed. On the other hand, you lack the opportunity to benefit of the precious review of the Department of Execution and peer pressure of the Committee of Ministers regarding the regular process of the reform and its good direction. the question is, could this be in each and every case counterbalanced by the possibility to benefit from the informal exchange of good practices of other states? Thank you for your attention.
Thank you very much. And there was something that we discussed also in the morning about, I think there were questions about what do we mean by deficient execution. As you say, you could find an execution deficient for a very long period of time, and it depends from where you look at it. And thank you for bringing that question about how long could supervision continue. So let me turn to Judge Yudkivska. She's judge of the European Court of Human Rights from Ukraine, for some reflections from her and how these questions perhaps look from the other side of the street. Thank you.
Thank you very much, Bashak. Well, that's indeed inspiring discussion, of course, and it's impossible to address this issue within such a short period of time. But yes, we do reflect on the other side about the effectiveness of the whole system of human rights protection. That obviously depends on enforcement, proper, correct, and timely enforcement of our judgments. Now, let me start with a formula which was proposed by the Harvard professor Beth Simpson in her wonderful body of research called Mobilizing for Human Rights. So she investigated why states ratify human rights treaties and why they further comply with them. And as a result of her study, she suggested that the governments are more likely to ratify human rights treaties with which they can comply at a reasonable cost, and political benefits should exceed such costs. So the human rights system will be successful when it is clear for national authorities that the costs they would bear by enforcing the court judgments, meaning amending relevant legislation. I'm not talking about now individual measures, but about amending legislation and practice according to the court standards whenever it is required, is less than the cost of non-compliance with the court judgments. And it does not mean that making legislation and practice compatible with the convention should be cheap. No, it should be always reasonable. Yeah. For example, when it comes to changes of the constitution that is sometimes required by the conclusions reached by the Strasbourg court, it's really serious, and it's really, put it in inverted commas, expensive. I'm not saying that it should not take place. Of course, it should take place in situations where it is strictly necessary. But again, it should be reasonable, and perhaps some leeway in the meantime should be given, like, as example case L versus Lithuania about transsexual, where under Article 41, the court said, well, either the state amends the legislation within 3 months in order to help this person, or states paid the amount of money which was specified in the judgment. So, of course, it was not easy and cheap to amend within 3 months legislation. So the applicant was paid, and apparently general measures are still not enforced. Now, but what I want to say is that non-enforcement of the court judgments should always be expensive, costly, and we hope that it will happen. And we expect maybe a stronger action for deliberate failure to enforce the Strasbourg court judgment from other bodies of the Council of Europe. I just opened our chat, and there is a question precisely on this issue. A participant asked about our opinions about the role of political will in the process of execution. Yes, that's all about political will, and of course I'm not in a position to address this. Yes, Article 18 cases just mentioned by the first speaker as a first to receive strong reaction in case of non-compliance. I'm speaking, of course, about individual measures. General measures in Article 18 cases are much more complicated, and I agree here with Christos. Now, when new democracies joined the Council of Europe, of course, it was difficult for them to execute the court judgments promptly. But the critical issue today is not some practical difficulties in enforcing some judgments or decisions, as was just mentioned by Isabel, and maybe maybe the crucial problem is not even Ukrainian situation, a failure to enforce Ivanov that eventually led to Burmich. I'm sure it was discussed during the dates. In itself, very serious problem, and I hope it remains isolated in the convention landscape. But the biggest problem the court faces today is a conspicuous non-compliance by some states with some judgments. And here I respectfully disagree with Christos. Yes, we do have this problem. Now, this deliberate failure to enforce might include a kind of like rejection position by highest courts of the state, like in case of when we adopted case of Yeremenko versus Ukraine, and the applicant eventually went to the Supreme Court claiming a rehearing of the case. Supreme Court said, but we disagree with the Strasbourg court that the applicant was ill-treated. No, he was not. And then it led to the further judgment Yeremenko 2 versus Ukraine, because the applicant returned to us. Case of Bochin versus Ukraine, where the Supreme Court said, well, deliberately misinterpreted what was written in the Strasbourg court's judgment, and the Grand Chamber, which took the case Bochin number 2 versus Ukraine, in very strong language criticizes, arbitrary interpretation of the Strasbourg court judgment. But it also can include, for example, enacting legislation that would prohibit executing of Strasbourg judgments that deemed to be contrary to the national constitution, and subsequent rulings by the Constitutional Court that certain judgments cannot be enforced because they are deemed to be contrary to the Constitution. There is this very serious problem. This is abuse, a deliberate failure to enforce judgment by this court. And it is, of course, a direct challenge to the convention, and I believe it should be a food for thought for the Council of Europe bodies. But in any case, it should not be a basis for assessing the court's ineffectiveness, and nor should the court be discouraged from efficiently reacting to the most problematic issues of the states. And efficiency also means to indicate by the court, of course, strictly where it is necessary, specific remedial measures. Of course, when we are dealing with systemic problems, they are most difficult for a state to tackle, and therefore the court at some stage reconsider its long-standing position that, well, the choice how to enforce judgments remain with the state under supervision of the Committee of Ministers, unless violation found by very nature does not leave any choice as to the measures required to remedy it, and it were situations like Asanidze, Futulai, or most recently Demirtas number 2 versus Turkey. So no other way to enforce judgment than to release the applicant. And in this respect, in Burmich, the court again underlines that, well, division of labor between the court and Committee of Ministers now has developed with regard to changing circumstances, and notably with proliferation of structural and systemic violations of the convention. Now, Burmich, of course, again, was very specific, and it was unprecedented judgment, which was a consequence of long-lasting non-enforcement of firstly ordinary judgment by the court, and then pilot judgment by the court, which pilot judgments themselves, in many cases, as a consequence of failure to comply with the judgment in ordinary case, raising the same problem. So now the court proceeds with indicating such measures without previous history of similar violations of non-compliance, if it is clear that the problem stems from legislative gap or failure that is to be repaired as soon as possible. So we should not wait for many judgments addressing the same problem before we proceed with pilot judgment and ask the state to change relevant legislation. And now with the new policy, I'm sure it was also discussed this morning, we have this new policy of impact cases, and here these impact cases most probably will give court a possibility to also reflect on specific remedial measures we will put to this judgment. Thank you very much.
Thank you, Judge Utkivska, for this very layered intervention, and also looking and responding some of the earlier questions about how can we think forward in the light of the constraints that we have. Let me turn to Professor Philip Leach, Phil, on some reflections and remarks and how we may think forward. The floor is yours, Phil.
Thank you very much indeed, Bashak. And I would like to thank all the speakers and the participants for your questions today. It's been, I think, there's been an incredible body of expert scrutiny on this issue. And most people having expressed incredible concern about this great problem. I would like to just pick up on 6 points very quickly in my 6 minutes. So I've got 1 minute each. That I think where we need perhaps more thinking and more investigation. And I'm going to start with the issue of transparency. I do still think that the Committee of Ministers supervision process needs greater transparency. Now, there's no question, as some of the speakers have said, that it has improved, the HUDOC exec database and so on. So there have been improvements, and I accept the need in a lot of situations for diplomatic confidentiality, but what we've heard today, it's very, very clear that in some situations, very serious cases, repeat violations, where there's been a long record of lack of cooperation or engagement by the state, that those situations could justify greater transparency. So so there's some public dialogue in relation to the supervision of these judgments. And that, I think, should certainly involve, as a number of speakers have said, better engagement with civil society and a better dialogue with civil society. The second point is accountability. Again, I think partly this is about, in some cases, in the most difficult, serious cases, senior officials, senior ministers, if necessary, being called to account and being called to answer. And there are processes in which that is possible in the Council of Europe system, having some kind of hearing, which could be in private, but it could also be in public where that's necessary, to have senior people called to account to explain. There is room for PACE, for Parliamentary Assembly, for the Committee on Legal Affairs and Human Rights to carry out that kind of role. And linked to that is the point of in-country presence that I think a number of people have picked up, and I think is alluded to in quite a lot of research on implementation in recent years, by having a presence, by holding, say, a hearing or having a mission in country. It's also, I think, clear that improves interaction between the international and the national levels. And as everyone has said, it's at the national level where implementation really does happen. And linked to that is the point that many people have made of having an effective national implementation and coordination structures in country that then do cultivate proper engagement with, as Alice called them, compliance partners at the national level. The third point is on the court's practice and the specificity and other aspects of the court's judgments that a number of people have mentioned, including the possibility of non-monetary measures of redress. And Øyvind Stiansen spoke right at the beginning of the day of the evidence that Article 46 judgments do make a difference. And I think linked to this point is the practice of the court in relation to friendly settlements and unilateral declarations that Veronica mentioned. So I think it's a key area where I think more could be done. Fourth point is Committee of Ministers interaction with other bodies and or the implementation process interacting with other bodies. We heard Alice talk about ECRI. We heard George Stafford from EIN talking a lot about the EU rule of law procedure. Again, I think this is incredibly important. One example from ERAC's own recent practice is in relation to the endemic problems of the non-enforcement of grave violation disappearance cases from the North Caucasus and Chechnya in particular. and our attempts to engage to link up the UN Working Group on Disappearances with the Committee of Ministers, and to see what extra benefits could be gleaned from the Council of Europe and the UN working together on those kind of impossible issues, or apparently impossible issues. Fifthly is the issue of resources that so many people have mentioned: resources for the court, resources at the implementation level. I think we need to come back to that. And finally, a little bit more substantively on this question of reopening of investigations, something that Christos and Isabel both picked up. I take the point, of course, about the problems of reopening very old investigations, but in some cases we see the very, very basic steps have never been taken. Very basic steps of identifying and interviewing key witnesses. So there is still every reason why those kind of steps could be taken and should be taken. I think there's more scope for the court to do more on this. So, for example, in friendly settlement and unilateral declarations in relation to such cases, where we do see one of the consistent terms being the need to carry out an effective investigation, it doesn't then happen. Well, is it possible for those agreements to be more specific and to have perhaps 1, 2, or 3 specific elements of the investigation that need to be carried out, and then it would be easier to try to ensure the implementation of those steps. Those are my 6 points. Just in finishing, it's very clear, I think we need to be creative. We need to be active, dare I say, radical in thinking through some answers to the problems of icebergs we've heard about and alarm bells, or whether they're funeral bells, so that this endemic problem of non-implementation can be improved. States have a huge responsibility here. And we heard sadly from Andreas von Staten early this morning that sadly states are pushing the boundaries of minimalist compliance in the wrong way. And they have a huge obligation through the Committee of Ministers and at the national level. And I have to say, I shake my head in dismay at some of the interventions from government agents today, including in the chats. And that's not aimed, of course, at my co-panelist Isabel, or to the intervention from the German agent, but I do shake my head in dismay. For the majority of states who hold the ring, there is a challenge here, I think, to bring one I think possibility to bring the kind of group of diverse experts you've heard from today, to bring them together to form specific proposals so that we can ensure there is some effective change. Thank you very much indeed again to everyone.
Thank you very much, Phil. Also for the structure of those 6 points. So I'm going to turn to our last speaker of the day. Professor Clara Sandoval-Villalba. She's professor of law and co-director of the Essex Transitional Justice Network, and she's from the University of Essex and has done extensive work concerning, in particular, not only, but in particular, the inter-American human rights system. So you've heard us talk about this system, Clara. We're, a lot of details about what happens in our eccentric system in some ways, so we'll be very, very interested in hearing how, what kind of reflections you took from this day. Thank you so much.
Thank you so much, Bashak, first of all, for the invitation to be part of what has been for me a great and continuously revealing conference. And also thank you, Philip, for allowing me to be here today. I am an inter-Americanist, and I have been hearing a lot and thinking all the time about how to contrast the systems. So I think that I would like to share with you first 3 key features that come to mind when I think about the ecosystem, to follow Alice Donald this morning on implementation in the inter-American system that certainly shape the work we do in the region. And those are the process of monitoring compliance in the America is by essence dialogical. And I think that's a key element that I want to stress here looking forward. The second one is that civil society, and I note victims have center stage. It's not only civil society and it is not only legal representatives. Victims have center stage. And the second one is that both the Inter-American Commission and the Inter-American Court have played a pivotal role that goes beyond monitoring and really encompasses issues like cajoling and definitely promoting through a diversity of means, some of them incredibly innovative implementation of their recommendations or their decisions. And I think these three features are things that I would invite you to definitely reflect on when considering the future of Europe. And so now let me contextualize what I have in mind. The work of the Inter-American Court is very different to the work of the European Court. Currently, up to 2020, the Inter-American Court was monitoring compliance of 237 cases. And you would say, of course, that doesn't even compare to Europe. But the Inter-American Court was monitoring compliance with 1,231 different forms of reparation that are of diverse nature and incredibly complex, many of them including guarantees of non-repetition, rehabilitation for victims, not only compensation, and issues of land restitution, etc. So issues of great complexity. And if any of you have had the opportunity to look at judgments of the Inter-American Court dealing with reparations, you will also identify very quickly the degree of a specificity of each of the measures ordered by the Inter-American Court. And while the Commission used not to be so specific, what we are seeing is a tendency towards being far more specific in its measures. And it does also apply in relation to friendly settlements. So the Inter-American Court has a growing docket in terms of what it has to monitor. And of course, these create challenges. But the Inter-American Court, I'm going to start there, has put together an innovative set of tools to monitor compliance that includes issues like resolutions, orders, notes of the secretary, hearings, and I will emphasize this point a lot here, hearings which are both private and public, on-site visits. We have a court that is ready to go out of Costa Rica and go into the field and visit indigenous peoples to see with its own eyes whether the implementation of its judgments are happening, and to listen to victims, to hear what victims have to say about what the state has done, and to bring state authorities to those places, authorities who had never ever visited them. So I think this is an incredibly innovative issue, but it also holds in-country visits because some of the sessions of the court happen in different countries from time to time, and the court also uses those opportunities to engage with the state actors to get the most of those visits. And of these measures, as I was saying, I would like to definitely highlight hearings, again, noting the dialogical dimension and noting something that could be a lesson that you should reflect on. And why do I say this? Because these hearings involve civil society organizations, legal representatives, and the victims, if they wish to be part of them, of course, states, but they can also involve various members of the state, not only the Ministry of Foreign Affairs or the legal representative and the like. So they have really proven to be a key vehicle for implementation of the measures. The court uses them strategically, and they are also strategically requested by the practitioners. So they see them as a key opportunity, for example, in relations to cases where there is deficient or delayed execution to activate implementation, or they see an opportunity in the state. Politically speaking, there is a change of political factors in the state that would allow that hearing to really have an impact, as happened, for example, with death penalty in the case of Guatemala. So are a key moment to really get back to the table. Some of them can be private, some of them can be public. Public are really exceptional, and they really happen like a stick. It's a way to really exhibit, put the state really to face the world for having done very badly in terms of implementation. And of course, the states don't want to do that. They don't want to be the bad guys. The private ones are very informal in a way. They aim to come up with action plans about how to go about implementing the different measures. Interestingly, these hearings, both of them have brought to the table or to the court other actors in the state, for example, members of the Ministry of Health or finance, etc., that are really key to trigger implementation. So the more actors you get to the table, the better. But it also allows the court to better identify what are the obstacles that don't allow implementation to happen, and to really guide the parties on how to go about implementation. They facilitate communication, they facilitate persuasion, they allow iteration of points that the court wants to make. In a way, they allow transformation. Victims participate, victims can talk to the court. And I really want to accentuate this point. It's very different when a court decides based on paper than when a court hears a victim and can ask the victim directly about what are the harms, what are the failures that they see in a particular situation. That possibility is crucial for the court to have a better understanding of what it could do in its role. They also help, and this has been crucial, to prevent that states take backward steps. We not only need to think about how we ensure that these decisions are implemented to the future, we also need to ensure that what we have achieved so far is not going to go backwards. And we have had a few states in the Americas, like Peru and Guatemala, that have tried to adopt amnesty laws after the court has said to them in various cases that they have a duty to investigate these gross human rights violations that occurred during an armed conflict. So when the state, for example, of Guatemala tried to do that 2 years ago, the court immediately called for a public hearing and also used provisional measures to put Guatemala against the wall. And that immediately hampered the process Guatemala had initiated domestically to try and adopt a new amnesty law. So going backwards, the court would stop also that. And it also can activate other actors of the ecosystem that Alice was talking about. And I think this is absolutely crucial. Amicus, experts that can provide the court with better information about guarantees of non-repetition, about how to ensure that they are implemented, or what is the situation really on the ground, because the court does not always have that information. And it has been noted also by studies like that of Aníbal Pérez Liñán and Angie Garcia, that within 1 and 2 years of these hearings, you see important impacts and important implementation happening. So it's not really that this is a nice dialogical process, it's also that we are seeing transformation and implementation of these cases. The other point I wanted to make, and I hope I'm not taking too much of the time, but is related to something that Veronica Fipka talked about this morning, and is the issue about friendly settlements, as it allows me also to show you the Inter-American Commission work. And she said some things that I absolutely agree with. I want to say that the Inter-American Commission since the 1980s has adopted more than 150 friendly settlements that are framed by 2 key considerations besides the dialogical dimension. Consent, so consent not only of the legal representatives, but of the victims, again, victims at the center. And also the idea that you need to respect human rights. So it's been incredibly discussed in the system, whether, for example, you can have a friendly settlement for enforced disappearances. And we have had changes in relation to that. So I think it's a very important question to put on the table. And since 2011, the Inter-American Commission accentuated the role and value it wants to give to friendly settlements, not only because it sees that as a way to manage the backlog of cases, it is, but it cannot be seen only as that. It has to be seen primarily by what it really is. And it's a tool that definitely can help us to implement decisions. And when the Commission was asked, check your results on that, what it found out was that, yes, friendly settlements were being implemented, and they are, as Veronica was saying, really comprehensive in terms of reparations. And we have, there is a beautiful video that I might share with you about the successes of friendly settlements dealing with guarantees of non-repetition that, of course, not only impact the victims in the case, but society at large. So you have success on that too. And I think this is very important. But the most important thing I would like to accentuate in relation to friendly settlements is that it's a paradox. These settlements at the Commission tend to take time. And I will give you an example in a minute. But that time is not dead time. And that's the nice part of that period of time. And is that they trigger compliance. Why? Because when a case is being negotiated for a settlement, the case is not immediately closed. What happens is that the Commission wants to see that changes are actually happening, that implementation is actually happening. And we have a case, for example, Dos Herdes, that we investigated with Phil and with Alice in our research project on implementation. And in that case, for example, although an agreement had been reached with Guatemala on this terrible massacre that happened there in 1982, many measures were implemented by the state, compensation and some symbolic measures, but collective reparation had not been implemented and the duty to investigate had not been implemented. And the victim said, we are unhappy. This is not full implementation and we want the case to go to the court. And this happened after 6 years of negotiation and waiting, and the Inter-American Commission sent the case to the court. And there is a second case that I think might also be interesting for all of you, because I think this case is going to be an emblematic decision of the Inter-American Court, and it's coming up this year, and is the case of the Patriotic Union. And in that case, more than 6,000 victims are at stake, and the negotiation process lasted for about 10 years, between the year 1997 to 2006. And the victim said, we are unhappy with what Colombia has done to deal with the alleged genocide of a political party in the country. And we would like the case to go to the court. At the end of the day, Colombia decided to send the case to the court. First case sent to the Inter-American Court by a state. And this also talks about the resistance to the system. Anyway, I think what we learned from the Americas region is that this dialogical process has produced results, particularly with the states that are part of the dialogue. So the typical ones, Peru, Colombia, Guatemala, Argentina, Ecuador. But those that tend to be outliers, that do not want to engage with the system, they remain really on the sides and they remain a problem. Countries like Venezuela, still party to the organization, although it denounced the American Convention. So I just would leave it there, Bashak. Sorry for taking more time.
No, thank you. Thank you very much. I didn't want to interrupt you because it's, you know, to hear about a system and practices that we're not really accustomed to thinking and using is also incredibly refreshing. So now this is the moment of a tough moment for me as a chair. We have about 5 minutes to finish off, and I have a few hands. So I don't think I'm going to do another round for my 5 speakers to make more comments, because I think everyone has already made their thinking comments. So I see a hand from Konstantin. If I could come back to you, but I'm not so sure I will be able to get you answer questions, Konstantin. Let's see what you're asking, because I have a few minutes to conclude.
It's not a question. I have 2 very quick comments. I will take 60 seconds of your time, hopefully. The first thing to Christos in relation to principal resistance, well, at least I will express our own view on that. This term actually started to live by its own after we published about it. And what we meant is that it's not the reason for non-execution. It's the explanation, it's the reason for unwillingness to execute. So it's why different states would not be keen to execute the judgment, but it is not a justification for non-execution, and it's not a good reason for non-execution in any case. This is number 1. And the number 2 is about Inter-American Court of Human Rights. I listened to this very interesting, innovative ways of dealing with execution with great interest. But I think that if it is to be implemented in the European system, it needs to be implemented with a critical sort of hat on it, because many of those very interesting innovative ways of dealing with execution will inevitably lead to they will demand a lot of resources. I mean, both time resources and financial resources. Although listening to victims sounds like amazing and really great idea, but then how much time it will take for the court to do all of that. And this will mean something that Adam actually absolutely rightly mentioned when he said that justice delayed is justice denied. So if we allow thousands of victims to come to the court and talk to the judges, those hundred thousands of victims will have to wait for 25 years before they are heard. Thank you very much. And sorry for taking more than 60 seconds, actually.
No, that's fine. Would you like to come back to that, Clara, especially that last moment? Maybe just I'll give you the floor very briefly, because this is also really eye-opening for us just to listen to those experiences, please.
Okay, so on the critical hat, Konstantin, I fully agree with you. A critical hat, I'm not saying that you need kind of to, put from here to there, because it needs to adapt to context and to your own culture, legal, among others. But I do believe that a missing piece of the puzzle in Europe is victims. And I think victims have really informed our law and the way the system applies the law. And it's something that you need to consider. How, I leave it to you, specialists, to figure it out. You will need to consult victims and you will need to consult civil society organizations. But on resources, I just want to know this. The previous panel was saying that the total amount of money of the European Court is 75 million euros a year. The annual budget of the Inter-American Court is about $7 million US a year. The budget of the African Court is about almost 11 million US dollars. So of the 3 regional courts, it is the Inter-American Court, the one that has the least amount of money and the least amount of people too. Yes, and still they are being able to use all the tools I mentioned to deal with the cases we have. Now, I know that for you, the amount of cases is exponentially bigger, but you can use your pilot judgments, the ones that you have prioritized, etc., to play a key role for that. And you can work with civil society organizations to gather the views of victims. So you should not be afraid of what that represents. You just really, you need to engage with victims. And we've done it. I mean, not all victims want to go to court. And this is something that you need to remember. But there are different ways also to participate, which is not only a hearing. They can also do it through a paper, through a video. And that's something we are using more and more at the Inter-American system. So I think there are different ways one can be creative, and you will need to figure that out.
Thank you. Thank you so much, Clara. And I think this is a very good note to close our final roundtable and the workshop. I'm aware that there were more comments and questions, but I think the time has come for this outstanding audience, panelists and listeners who've just also stayed with us in incredible numbers throughout the day. So Clara said we need to continue to think creatively, and I think Phil and others also have emphasized this. We have quite a lot of research. This is how I started. We're building a lot of know-how on execution dynamics, both from legal and from political science perspectives. And I think we have a lot of ability to identify problems in different areas, as well as learn from comparative experiences. So what kind of gives me a very sort of, makes me finish on a very positive note is 2 things. One is that we are, as a community of 47 countries and individuals living under the jurisdiction of these, are really part of an extraordinary enterprise. This still is a pretty extraordinary thing that there's a court, a compulsory court, with jurisdiction over 47 member states, and there's a system for monitoring of the binding judgments, and a collective commitment and a collective institution to do so. These are quite outstanding institutional models, but we have to work on them very creatively and comparatively. The second thing has been the audience participation today. I see that there is a very significant interest in the execution of human rights judgments, to have these workshops with people never dropping under 150, starting from very high 200s is outstanding. I think for you have all endured a full day of this workshop and discussions and contributed greatly. So I thank you very much. And lastly, of course, I'd like to thank my co-organizers, Philip Leach and the German Ministry of Justice and Consumer Protection, also the fantastic team at the Hertie School, Hertie Center for Fundamental Rights, Dr. Kramer, Paul Kunz, who were at the background supporting all of this, and everyone else who have made this truly a great workshop. And I think we have all learned, I have certainly learned, and I more than how I started this morning. So thank you very much for taking part in this workshop today.